Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault. And you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy. The dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Anglican for you, sir.
Scratch all that. That was terrible. I apologize.
Is that correct?
Good morning. Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. A little too saturated on the camera. Too far on the colors there. Hang on. It's a little much. Let's dial that back just a hair. There we go. Good morning. Good morning. Welcome. Happy Friday to you. It is Friday. The weekend is upon us. Let's see. Nice 10 you got there. Yeah, it's all done in camera. It's like After Effects. Music's a little loud this morning.
The apocalypse may be upon us.
I think it is. Are you a DJ too? No. These are camera settings. I'm not like spinning ones and twos. But you know, I've always looked at those DJ setups. I thought that would be fun to learn. Mostly because there are so many buttons. I'm a big fan of buttons, as you know, and DJs have all the buttons. Okay, we'll figure out why the lights are doing what they're doing in a minute. But happy with the camera right now. I think the problem is this camera is so sensitive that as the daylight changes, as the sun comes up in ahead of me to the east, and then goes overhead, the lighting changes so dramatically in here that I have to adjust the camera. But I think I fixed the brighter, darker thing. So fingers crossed that we've got that corrected. All right. Good morning. Good morning. Happy Friday. The birthday shout-out form is now closed. You know what I did this morning? I discovered a new place where people have been reaching out to me directly for communicating questions, input, suggestions, things like that I didn't know existed. And it was like tied to Instagram and Facebook. And so I just found months of messages, like other content creators reaching out saying, hey, can we do this? We've both been following the same case. Can we do? Yeah, I had no clue. I had zero clue. I just didn't know where the messages were. So if you ever sent me a message on Facebook Messenger and I didn't respond, it's because I didn't get it till today. I'm that good with social media. But anyway, so I'll try to start responding to some people here. Every message is going to be like, "I'm so sorry." Is how it's going to start. I'm so sorry. Welcome to the party, Melissa. I'm learning. Who says you can't teach an old dog new tricks? Thank you, everybody who joined us for the podcast last night. It was a lot of fun. Thomas and I had a blast. Hope you did as well. Covered some really funny stories as well. So a good break from the heaviness of what is every day in court. We'll have to start sending super chats there. Says Vibrant Squeaks. Tyler, I've never thought of creating an app. It always seems like more work for me. I think the cleaner the better, right? If you guys are here and able to just chat and it works in the chat here, that's preferable. Another app is another thing to download and install and use and switch to, and I'm not sure. You convince me otherwise. I mean, I'm open to change my mind, but convince me. Do you check your Christmas lights out after the podcast? It was late after the podcast. I like to hang out and talk to Thomas a little bit afterwards, and by the time we were done talking and chatting, it was late enough that I thought I'm not going to go out there with a flashlight to check my Christmas lights, and so I didn't. All right, we have, oh my goodness, look at this. Great people having their birthday today. Banshee, Kiki's Garden, Natalie O, Jonathan, and Melanie have a wedding anniversary. That's not a birthday, but Jonathan and Melanie. So Banshee, Kiki's Garden, and Natalie O all have birthdays today. That's going to be special because we get to sing to them. Jonathan and Melanie, congratulations on your 15th wedding anniversary. That is awesome. What isn't there like a chart somewhere that says on this anniversary you get your spouse XYZ present? And I think the form that the guys use for that, like every single item is jewelry, right? But what did the women get the men on the wedding anniversaries? I'm curious. What's a 15th wedding anniversary gift? Hang on. Kiki's Garden says, my birthday is January 29th. Why do we have you on the birthday list? Did you tell us your birthday was today? Oh, chat's not on screen. Now it is. Fixed it. Sorry about that. Thank you, Thomas. My package is ready to pick up at your post office box. Kiki's Garden. Thank you. I will head down there and check it out. Is it 10 cables? Okay, power tools, power guns. Power tools or guns. Cardboard is 15 years. Like a box? Is that a terrible joke, Lizzie? It's like, hey, you made it 15 years. Now pack up your stuff. Oh, that's awful. Kitten, better than jewelry. 15th is a chainsaw, Bob. I'm on board with that. Okay. No miscommunication. Okay, so we're going to sing to Kiki's Garden, whose birthday is January 29th. It's not how we normally do it. I'm a little confused. Someone will have to explain. Oh, was it? Oh. I think this needs a period right here. Like, no, it was miscommunication. Not no miscommunication. So you literally miscommunicated on your no miscommunication. Miscommunication. We got it. So, Kiki, are you saying we'll give you a pass on the birthday song today and wait until January 29th? Would that be better? So we'd sing instead to Banshee and Natalie O, which is great. We're happy to sing to you as well. 10th anniversary is cables. Mm-hmm. Okay, here we go. Kiki, thank you for the super chat as well. Let's see. All right, new and updated Sharon. Thank you very much. By the way, Sharon, if you guys don't realize this, Sharon does this every single morning, putting together a list of who has birthdays and when, and keeping track of this. You guys all love the birthday song. It wouldn't happen without Sharon. Sharon, thank you. Sharon's the gal. But thank you. Really, really appreciate this, and it's hard work. I mean, it's having a couple hundred people suddenly tell you, chatting and trying to pick out who says what, and birthday forms and everything else. It's great. You do a wonderful job, Sharon. Thank you. Thank you.
Send someone with more experience.
I need some more experience. I do. Here's what we're going to do. We're going to sing. We're going to sing to Banshee and Natalie O, and we're going to think of Jonathan and Melanie celebrating their 15th wedding anniversary today with chainsaws and cardboard, and maybe a kitten. I don't know. Not all three together. But let's do this by everyone stand up, take a deep breath with me. Shoulders back. Project your voice to the back of the room. Blend your voice with your neighbors. Warm up with me, if you will. La 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 la. Excellent. I think we're ready. We're going to sing happy birthday to Banshee and Natalie O. Answers are ready, go. Happy birthday to you. Happy birthday to you. Happy birthday, dear Banshee and Natalie O. Happy birthday to you. Banshee, Natalie O. Happy birthday. today would be a good day to go over to Discord if you haven't. I mean, I'm not talking about just Banshee and Elio, all of you. Discord's a great place. We have a lot of people who are interested in some stuff that's over there, including the pictures that Denise took in the Brian Koberger's court yesterday. And for her birthday, it would be great to just go check that out. All right, happy birthday. I realize there are a million places you could be, a million people you could be with. You've chosen to be here with us. Thank you. The privilege and pleasure is all ours. Hopefully we can make your day a little more special and kick it off with free pancakes at Denny's, IHOP, Village Inn, Wendy's. Wendy's doesn't do breakfast. I don't think they do breakfast. McDonald's, Andy's Grill, not Bar and Grill. Should have bar in there. I'll go talk to Andy, see if he'll add a bar. Happy birthday. Natalie O says, thank you so much for the birthday wishes. Love you guys. Congratulations, Natalie O, on your birthday. 12 months. Ding, ding, ding. Congratulations, Natalie. You got that orange courthouse. That is beautiful. Jenny R, happy birthday on Sunday. We can sing on Monday if that works. That'll be the closest date. Because we could sing today, but Monday might be a little easier. Happy birthday in advance, Jenny R. Happy birthday. It's a birthday weekend. I love this song. I'm going to sing anyway. Happy birthday to you. We're singing to Jenny. Happy birthday to you. Happy birthday, dear Jenny R13. Happy birthday to you. I was saying right into the drum solo, which I had to focus on singing, but I did hear you guys do the drum solo. Great job. Great job. Happy birthday, Jenny R13 as well. All right, we have Friday. Typically, as we're doing court hopping, as we wait for our next trial to start, we have mostly landlord tenant stuff, which sometimes can be a little heavy. Sometimes could be, we'll see. We might jump around a little bit. Sometimes it's really fun. But we are going to backtrack just a tiny bit with Judge Simpson and see who he has in store for him this morning. Wait. Where did it start? Right here, just a couple minutes ago. Right there. Boom. All right, here we go.
Court, County of Washington, State of Michigan is now in session. All those having business before the court draw near. The Honorable Judge J. Cedric Simpson presiding.
And good morning.
Good morning, Judge.
Court does call the case of Arbor House Apartments versus Khalid Mahmoud.
Max Mahmoud, I'm the plaintiff, Your Honor.
Good morning, Your Honor.
All right. Mr. Mahmoud, do you have a camera? Do you have a camera? Good morning, sir. All right. Okay, what is plaintiff's claim in this case?
Your Honor, at this time, we're indicating that there is a balance owing, a rental amount owing in the amount of $3,688, court costs in the amount of $178, giving us a grand total of $3,866.
All right. And sir, how do you intend on getting this paid?
Yes, I do, sir. Actually, so I filled out an application with the Michigan benefits. I forgot the name. State. I have a case number. And
state emergency relief.
Yeah, state emergency relief. So he talked to me and he said that he would have knew, because last court that we had, I don't know, it was a mistake. I guess they took me to the wrong court. So he's been waiting for my papers and for me to send him something so he could try to help me out with this.
All right. But if it's state emergency relief, how many people are in your household?
4 altogether, sir.
All right. So that if you get the maximum amount of benefits, that's going to be $740.
And then I was planning it to make some payments this week. I was going to pay like probably for like 500, then next paycheck probably 600. You just break it down, just try to get it as low as I can, sir.
All right. So you're going to pay $500 by when?
By, let's say today is Friday, Monday. By Monday, I'll pay 500, then I get paid Friday.
All right. I'll make it Tuesday because Monday's a holiday. So you're going to pay 500 by the 12th. You put in an SER. There's a form that you have to fill out, get to the court by next Wednesday. You can get the form either by looking in the chat online, or you can use the QR code, which will take you right to the form that you need to fill out.
Yes, sir.
Understand that?
Yes,
but
sir.
That has to be in the court by next Wednesday.
Yes, sir.
All right. I would suggest, given the amount here,
Veterans Day
that you
Monday,
also
right?
might want to contact Hawk. Have you spoke to them, sir?
I did, sir. I guess it didn't qualify for their program.
You didn't qualify?
Yeah.
Okay.
So I have
right.
a job. I have a job, sir. I've been working at the hospital for almost 20 years, but I was recently laid off for almost 2 months for some incident that happened there. But I'm back at work now, and I'm getting this paid off.
Okay. But I'd suggest then, if you don't qualify for Hawk, that you may want to talk to your landlord.
I am.
All right.
That's I would do that.
Get that in. All
Yes,
right.
sir.
I will adjourn this matter then out to, today's the 8th. So what's my next day? My calendar isn't changed. I'll adjourn this matter to November 15th, 2024 at 1 p.m. Okay. That's in person, sir. All right.
Okay.
Your Honor,
Yes, sir.
I believe this is my only one for the morning. Would I be able to be placed in a breakout room with Mr. Mahmood, see if we can get an email from him so I can try to work out a resolution with him before the next hearing?
You want an email?
That is correct. If Mr. Mahmood's open to that for us to try to work it out before the next hearing.
Sir?
Yes, sir. If you're ready, I can give it to you.
You don't want to do it now.
No, don't broadcast it.
You'll make a lot of friends.
Can you type it into the chat?
Yes, sir.
Do we have it?
We do not.
We don't have an email. So if you type it into a chat, it will go to my staff and then we'll send it over to council if that's acceptable to you.
Yes, sir. That's fine.
All right. Do that. All right. Thank you.
You have a great day. You have a great day.
You do the same. Pines and Clover Lane versus Brooklyn Gray and Jade Gray.
Good morning, Judge. Christopher Asphalt, 53129, on behalf of the plaintiff.
We're getting a tour of the house.
You're not checked in. Grays, Brooklyn Gray, Jade Gray, they're not here.
Judgment.
Would you like to take a default? We paid for the second service.
I would, Your Honor.
All right, raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
All right, go ahead.
There's currently rent due and owing in the amount of $2,839.32, court costs of $214, for a total amount of $3,053.32. I would request a writ to issue in 10 days, which I believe would be November 18.
Yes. Yes, judgment to the plaintiff. That is by default for possession. Redemption amount in the amount requested with a writ to issue in 10 days.
We're gonna jump over to Judge Middleton really quickly. Let's see, search Judge Middleton. There we go. He's just getting started this morning. He was talking to the camera a bit, but I couldn't see what he was saying. Now he's waiting. So we're going to wait with him.
See who this is. Robert Melissa Grant.
There's Stephen Smith. You got his degree on the wall behind him there.
Good morning.
Morning, Your Honor.
Good morning, Mr. Bowman. Have a seat. Good morning. Good morning. This is Judge Middleton. You're not in any trouble, but your home has been foreclosed on, and we've got to deal with that. So I asked the jail staff to get you up and bring you in here. I had somebody else in momentarily, Motorola, but they're not here. So good morning, Mr. Smith. Welcome to Centerville.
Morning, Your Honor.
This is file number 241760. It's entitled KG 5517 LLC versus Ricky G. Bowman or any other occupants at 909 East Broadway Street, Three Rivers. Mr. Bowman is presently an inmate in the St. Joe County Jail. I had him brought in by Zoom so we could address this matter. Let's bring in. Anyway, Mr. Bowman, thank you. You didn't really probably even know this was coming, so they got you up and brought you in here. But let me tell you this. You are a defendant in a landlord-tenant action regarding a foreclosure. Your house was subject to foreclosure back in March, I think. It's been sold at a sheriff's sale, and they want you to move out so they can take possession of the home. You have the right to hire an attorney to assist you in this matter. If you cannot afford one, a legal aid attorney may be available to help you. She's usually here, but she's consulting with other clients right now. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you want a jury trial, you must tell the court at the first court appearance or make the demand in writing within 5 days using the jury demand form and pay the $50 jury demand fee unless the court grants you a waiver of that fee. You may be able to reach an agreement with the landlord by going through a community dispute resolution, mediation. If both parties are agreeable to that, the court can help set it up. You may be able to reach an agreement with the landlord. That means the case would get dismissed, in which case the court would assist you or counsel would file what's called a conditional order of dismissal. Mr. Smith, if I stated the premises correctly, this is a mortgage foreclosure action. The mortgage sale was in March. Notice to quit in this matter was sometime earlier this fall, and the complaint was filed in October. Mr. Bowman's been in custody for 17 days, so he hasn't had a chance to do much. Mr. Bowman, what's your position?
I believe I get out of here on the 30th of November, and I would really like to get my life turned around and see if I can get all this resolved and get going in a positive direction.
All right. Well, that's a good goal. Is anybody in the house?
I don't know. Like I said, I haven't been there in a spell, but I couldn't tell you honestly. I did have my wife's oldest and youngest daughter in there. It was supposed to be family only, you know what I'm saying? So that's the extent of what I knew.
Your Honor, I might mention that on the 15th of October, Mr. Stamper, Joe Stamper, I think his son-in-law, was served there at the home.
Okay.
So I'm aware of his presence at least on that day.
Okay, well, that would be the oldest daughter's boyfriend then, Joe. Yes.
That's like family.
All right, well, the house has been sold at a sheriff's sale, and the time to redeem it has passed. Okay. And so that was March, and they have to wait at least 180 days. So this didn't sneak up on anybody. You're in jail. They're there. They haven't responded to this, but they're going to have to move. I'm going to set this for another hearing next Friday, November 15th at 10:15. Does that work for you, Mr. Smith?
I'll look here real quick. Are you anticipating that hearing as per typical being our trial?
Yes, it'd be the second hearing. I'm not sure how much of a trial it will be, but
sure. And I certainly obviously need to be in St. Joe County. I have oh no, is that Zoom possible?
Yeah, it'll be Zoom.
Oh, fine. I have another hearing by Zoom at 9:50. So did you say
10:15? I can set it for 10:30 if that'll work better.
That should work fine. Yeah.
All right, Mr. Bowman, the law requires that I adjourn this matter at least 7 days, so I'm going to continue it to next Friday. If they get what they ask for, you and the occupants would have 10 days to vacate or be subject to being evicted. So that date would be November 25th, which is the day before, a couple days before Thanksgiving. As a practical matter, probably nothing would happen till December 1st. But I don't know if you have any communication with anyone that's there. They're living there. No one's been paying the payment on the house probably for several years. It was foreclosed on in March. So somebody's probably paying the utilities and keeping the lights and the heat on, but no one's making the house payment or probably the taxes. So you should try to get a hold of your wife's daughter because on or after the 25th of November, they could be subject to being evicted.
Okay.
All right. Do you still have your possessions there?
Yes, I do.
How long do you live there?
How long have I lived there? 13 years, I believe. Yes, 13 years or so.
Wow. He can't be in jail and move out.
Let me look at this. Shows an out date of November 30th, so you're correct.
Cinnamon Bear, welcome. Congratulations on 4 months.
Well, we'll address it further next Friday. If you don't bond out or anything, I'll have you brought in by Zoom once again next week. But you should communicate with the people in the house. They are close to being evicted.
Yes. I don't have any questions. I don't have any. Can I bond out?
No, you've been sentenced, so you're not eligible to bond out. You might get good time if you get extra trustee time or something, but right now it shows your out date as November 30th.
You're correct. I've been trying to get trustee.
All right. Well, good luck, sir. I'll see you either way next Friday.
Next Friday. Thank you.
All right. Thank you, Mr. Smith.
Thank you, Your Honor.
Man, Fridays are rough. Landlord tenant stuff is really tough. Hold tight here. Thought we had something from Cass County. That wasn't landlord tenant. Is anyone having buffering on their end? Got like weird stuff happening on my side. There's Cass County. I might need to work with this audio just a little bit. Let's give it a try.
Within your calculated guidelines for this offense, so I'm going to adopt that recommendation. So on the count 3 charge of attempted receiving, concealing stolen property between $1,000 and $20,000, It will be the sentence of court. You serve 132 days, Cass County Jail with credit for 132 days already served. The court will impose minimum state costs of $68, a crime victim rights assessment of $130, and a fine of $500, as well as attorney fees in the amount of $350 to partially reimburse the cost of providing legal assistance in this matter. And the court will assess court costs in the amount of $500, which the court deems reasonable based on the average cost of prosecuting a case here in the county. Again, as we indicated earlier, there was no restitution, so none will be ordered. Mr. Cologne, I would advise you do have the right to appeal your conviction here today. You can do so by filing an application for leave to appeal. I see that the deputy there has notice of appellate rights.
Let's get rid of that squeal.
If you do wish to appeal and you're financially unable to retain an attorney to represent you, and you want to have an attorney appointed to represent you, fill one of those forms out, return it back to the court, filled out, and I'll review that. And if you qualify, we'll appoint an attorney for you for an appeal. Any request for an attorney should be made within 42 days of today's date. I'm going to go ahead and remand you back to custody. The Cass County Sheriff be obviously transported to Berrien County pursuant to their warrant. And at some point, you'll need to make contact with the clerk's office here for make arrangements on your fines and costs to avoid any further contempt proceedings here in this matter. I saw you raise your hand. Was there some question you had, Mr. Glonis?
Yes, sir. I would take these for words of your advice and leading by example. So thank you very much for telling me those things. That'll be it.
Well, I think you've got the basics. When I saw you in the Swift and Sure program, I saw you could do it. I just don't know what, and if there is something that throws you off, it's that tool. You got to go to, instead of trying to resolve the issue on your own, go to those people that you trust. When the time comes. Obviously, you can't go to your parents now with the PPO, but there are other people in your life. Turn to them. Don't turn to drugs. Don't turn to other things. And again, that's something you're going to do. And like I said, you're really at that point in life, Mr. Valonis, you don't have a lot of time. You're either going to get your life squared around now, or you're probably never going to get it squared around. You're just going to be in and out of jail all the time.
Yes, sir.
All right. Attorney Ronnie, anything further?
Nothing further, Your Honor.
Attorney Feldman.
Nothing further, Your Honor. Thank you.
All right. Good luck, Mr. Valonis. Hopefully I don't ever see you back here. I hope you get yourself squared around, and if I do ever see you again, it's on the street, and I can shake your hand and say, good luck.
Yes, sir. Thank you very much.
You're welcome. We'll go ahead and stand adjourned in this matter. We do have Trent Conrad.
Same, Your Honor.
All right. We'll go on record and file 24-10061FC, People State of Michigan versus Trent Aaron Conrad. Mr. Conrad's case is on my docket for sentencing here this morning, although I did have a motion that was filed by Attorney Feldman to withdraw his counsel.
Yes, sir.
I don't know if you want to address that or if you had an opportunity to discuss that with Mr. Conrad before today. And also there was, I think, some mention in there that it would be his, or he wishes to withdraw his plea.
Correct, Your Honor.
So I guess we'll hear from you, and then we'll hear from the prosecutor, also hear from Mr. Conrad.
Thank you, Your Honor. I've had several discussions with Mr. Conrad over the phone and in person here this morning about how he wished to proceed on this. And I believe he wishes me to ask to withdraw from the case so another attorney can be appointed to discuss with him the possibility of him withdrawing his plea. Obviously, only grounds for that. But given that he has had certain discussions with me, the possibility of me continuing going forward on a motion to withdraw his plea and then proceeding to trial would not be possible under our ethics rules. So I am asking
I know he's guilty,
the court
and
to
I can't
withdraw
represent
from
him
the
if he's
case
saying
so
he's
that a
not
new
guilty.
attorney can be appointed to meet with him, discuss with him the reasons why he would want to withdraw his plea, and if necessary, file that motion. It would be based on him making the statements that he made in the PSI. I believe he feels that I bullied him into entering the plea. I recall the plea rather specifically. We went on the record, discussed the plea agreement. Everyone agreed with it, but when you went to the factual basis, he had a difficulty with it. We went off the record on this file. I think he went on the record with a different file, came back, and we went on the record. He completed his plea. And the question, and I believe I placed it on the record at the time, the question was one of penetration, given that he was pleading to CSC second after having been charged with CSC first.
Okay, so we're going to bail real quick.
I think.
Yep. Anyway, we've got in other notes. I just was fixing up the audio so it would work well. But all right, let's see. Nothing on the misdemeanor front for lots of courts. Let's see. We've got. It's going to be a quiet day today. Maybe when Thurston comes on board, they might have something exciting for us. No. Let's see if 14th Judicial Circuit is ready to have their moment in the spotlight here. 14th Judicial Circuit. Oh, I can't speak this morning. These are first appearances. They're just getting started. They just went live just moments ago. And we're not even live yet. So I guess, let's see. What's Super Source look like? Okay, so we'll wait. We'll wait here for a little bit while she gets her system online. Landlord, tenant. Let's see what Judge Sean Perkins is doing. Not sure. We'll hang with this one for just a minute. You keeping an eye on Delphi? No, only that we're aware it's in verdict watch.
Should have attacked everything. Good morning, guys. Let's just wait for that black box to come off of the screen.
That was me.
But in the meantime, let me introduce myself. Good morning, everyone at the jail. My name is Anna Garcia. I am the judge that's assigned to preside over first appearances this morning. Present here with me in the courtroom is Mr. Jake Mitchell. He is an assistant state attorney, and he is here to represent the state of Florida for these first appearances. Present in the in the first appearance room with you is Mr. John McDaniel. Mr. John McDaniel is an assistant public defender, and he is appointed to represent Mr. Webb, Nobles, Mr. Ash, Ms. McMillan, Mr. Brooks, Ms. Stevens, and Ms. Whitman for purposes of this first appearance here today. Jones, did everyone have an opportunity to watch the video regarding their first appearance rights?
Amanda, thank you very much.
Yes, it did. Excellent.
Podcast.
All right. Mr. McDaniel, who do you want to call first? Do you anticipate resolutions in any of our cases?
The last three, to be please. You just want me to go ahead and go down? I'm going to go down the list, if that's all right with you.
However you wish to proceed.
All right, so I'll go ahead and start with Brad Webb. Brad Webb, we'll do Donald Ash last, I think, Your Honor, but,
okay. Mr. Webb, good morning.
Good morning.
Mr. Webb, tell me your full name for the record.
Brad Webb.
Mr. Webb.
Brad Kendall Webb.
Excellent. Thank you. Mr. Webb, did you understand the rights that were explained to you on the first appearance video?
I do.
All right, excellent. Mr. Webb, you have been charged with 1 count of criminal mischief. It can be a second or first-degree misdemeanor or a third-degree felony, but based on what I read, it's likely a misdemeanor, punishable by up to a year in jail. You've been charged with 1 count of resisting without violence, also first-degree misdemeanor, punishable by up to a year in jail. And you've been charged with 1 count of battery on a law enforcement officer, third-degree felony, punishable by up to 5 years in prison. Mr. Webb, it's my understanding that you are out on bond in Jackson County case number 24 CF 284. Is that correct?
That's correct.
You've got an open count of felony battery? All right. Is there anything from the state or the defense before I proceed with release options?
No, Your Honor.
All right. Mr. Webb, on each of the misdemeanors, I'm going to set your bond in the amount of $2,500 cash or surety. On the felony, I'm going to set your bond in the amount of $7,500 cash or surety. If you make those bonds, you are to have no contact with the victims, and you are to not consume drugs or alcohol while you are out on bond, and you will be subject to random urinalysis. However, Mr. Webb, because you are alleged to have committed new law offenses, the court is revoking your bond in case number 24 CF 284, which means you cannot be released until that case is resolved. Do you have any questions for me about the about the release options that I have just identified?
No, ma'am.
All right. Thank you so much, Mr. Webb. Do we have family member in the courtroom, but who is it for? Mr. Brooks? Okay, fair enough. Thank you, Mr. Webb.
Your Honor, what was his bond total in the new laws?
12.5.
Thank you.
All right. Who do we have now?
Shadrick Nobles.
All right. Mr. Nobles, hello.
Hey, how you doing?
I'm well. Thank you. Mr. Nobles, you are being held for charges out of Leon County. I saw fraudulent use of personal identification. Did you see additionals, Mr. McDaniel?
I believe there was 2 misdemeanors and a felony case, or 2 felonies and a misdemeanor case. I thought when I went through it, and it was a bond of $5,500 total on those 3 charges. It was all in the same case number, in that felony case number 243187 CF.
Mr. Nobles, do you understand what you're in jail for?
No, ma'am. I don't know anything about that.
Well, so let me be clear. We don't know the details of the charges either. But do you understand that Leon County has warrants for your arrest for these alleged charges, and that Leon County has set bonds? And if you make those bonds, you just have to show up in court to respond to the charges.
Right.
Right.
Do you understand that, sir?
Yes.
Okay. So here's what I have. I have uttering a forgery and altered check. That bond is $2,500. Criminal use of personal identification information. That bond is $2,500. So that's the $5,000 so far. Then there's a $500 bond on a charge of petty theft over $100. The victim in the petty theft is a person named Claude Palmer. It allegedly occurred in May of 2024. And the uttering a forgery or altered check was a check allegedly passed to PNC Bank, also in May of 2024. Then finally, the use of personal the use of personal identifying information is alleged to have occurred also in May of 2024, and the victim in that case is also Claude Plummer. Claude Plummer. So, Mr. Nobles, we don't have any more information other than the warrants. The warrants have been confirmed by our deputies here in Jackson County. You'll have to go to Leon County to answer to those charges. But if you don't want to stay in jail and you want to post the bonds, you can, because Leon County has set preset bonds on those cases. Okay.
Stacy McMillan. Oh, I'm sorry.
Thank you, sir.
Thank you.
Ms. McMillan, good morning.
Good morning.
Ms. McMillan, tell me your full name for the record.
Stacy Lane McMillan.
Ms. McMillan, did you understand the rights that were explained to you on the first appearance video?
Yes, ma'am.
Ms. McMillan, you are being held for allegedly violating the terms of your state probation. I have signed a no bond warrant, which means that you will be held without bond until you answer to these BOP charges. Ms. McMillan, I'm going to appoint the Office of the Public Defender to represent you for this VOP, and I'm going to arraign you on the VOP today so that Mr. Green can come out and see you sooner rather than later so that we can get you on as early a docket as possible. Do you have any questions about your hold without bond?
No, ma'am. I appreciate it.
All right. Thank you, ma'am.
With Brooks.
We're flying through these first appearances.
Mr. Brooks, good morning.
Good morning.
No relation.
Mr. Brooks, tell me your full name for the record.
With Cameron Brooks.
Mr. Brooks, did you understand the rights that were explained to you on the first appearance video?
Yes, ma'am.
Mr. Brooks, you have family members present here in the courtroom on your behalf. I have 3 ladies here on your behalf. Do you want me to tell them who you are? Do I? Mother, grandmother, and girlfriend? Your mother, your grandmother, and your girlfriend are present here on your behalf. Mr. Brooks, you have been charged with 1 count of driving while license suspended or revoked. That charge can be anywhere from a 2nd-degree misdemeanor to a 3rd-degree felony, punishable by anywhere from 60 days in jail max to 5 years in prison max. It just depends on how many prior offenses there are. Mr. Brooks, it is my understanding that you are presently on state probation out of Bay County for allegedly fleeing or attempting to elude. Is that correct?
Yes, ma'am.
All right. Mr. Brooks, I'm going to set your bond on the DWLSR in the amount of... Go ahead.
We have a plea on the next 3 cases. This one here is a plea also.
That's fair enough, but I'm going to hold him on the VOP for 10 days to see if...
He's going to be in jail longer than 10 days on the plea offer, so...
Fair enough. Okay, fair enough. Okay, so what is the plea?
Your Honor, I've talked to Mr. Brooks. At this point in time, he's going to plead of no contest to driving license suspended. The understanding, he's going to be sentenced to 30 days in the county jail. There'll be a $400 fine. He'll have 1 day jail credit. He has signed his plea waiver form waiving his right to a jury trial and call witnesses.
All right. Is that the agreement with the state?
It is, Your Honor.
Fast track that one.
And does the defense stipulate to a factual basis for purposes of the plea?
Yes, Your Honor.
Mr. Brooks, will you please raise your right hand? Sir, do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. Mr. Brooks, you can put your hand down. Mr. Brooks, did you hear what your attorney just announced about resolving your misdemeanor case here in Jackson County?
Attorney's phone.
Yes, sir. Yes, ma'am.
Is that what you want to do?
Yes, ma'am.
Has anyone promised you anything other than what your attorney just announced to get you to enter into this plea?
No, ma'am.
Is anyone threatening you?
No, ma'am.
Mr. Brooks, do you understand that by entering into a plea today, you are giving up your right to go to a trial where the state has to prove these allegations against you?
Yes, ma'am.
Do you understand you're giving up your right to present any defenses that you may have to this alleged action?
Yes, ma'am.
And do you understand you're giving up your right to appeal anything except an illegal sentence?
Yes, ma'am.
Mr. Brooks, because you are on state probation, by entering into a no contest plea to this offense of driving while license suspended or revoked, this could be used against you in a violation of probation hearing should this should Bay County violate your probation. Yes, sir.
Judge, I forgot to put that on the record, but we generally say that they can set aside if they try to use the actual the conviction here. Now they can use the events of the case, but we usually just ask and the state agrees to not be able to use the actual, one piece of paper conviction to violate it.
Is that the agreement with the state? That's shocking because it's the 14th, right? So you're going to make your Bay County prosecutor prove it. And that's fine. If that's the agreement, I'm not blowing it up, but I've just never seen that happen in the 14th.
It's common practice in this courtroom action, though. Strangely enough, yeah.
Okay. Well, if that's the agreement with this, If that's the agreement with the state, I'm not blowing up the plea agreement, but then that's certainly the state's prerogative.
You can't hold my guilty plea against me
for
violating bond.
It is my understanding that the agreement is that if the Bay County Prosecutor's Office wishes to use this conviction against you to violate the terms of your probation,
I'll have to prove it in
that the state here in Jackson County will allow you to withdraw your plea of no contest on this charge. So do you understand that? Or do you have any questions about what we're talking about? All right, fair enough.
That's a sweet little
All right,
deal.
so with that, Mr. Brooks, I find that your plea is knowingly and voluntarily entered into after the advice of counsel and that there's a stipulated factual basis for purposes of the plea. I will now proceed to sentencing unless I hear otherwise from either the state or the defense. Mr. Brooks, in your most recent case number, Madam Clerk, what case number is that?
It's not.
All right, so in this case that we are discussing, this DWLSR, I accept your plea of no contest. Guys, is he pleading to a second or a first?
Just a second. I think it's a second.
All right, I accept your plea of no contest to 1 second-degree misdemeanor. So, Madam Clerk, even if it comes in as a first from the officer, we're pleading it to a second-degree misdemeanor. To the second-degree misdemeanor offense of driving while license suspended or revoked, I sentence you to serve 30 days in the Jackson County Jail and give you credit for 1 day that you've already served towards that sentence. Madam Clerk, what are the court costs? Even? Okay. I order that you pay court costs in the amount of $370, and that will be reduced to a civil judgment. Mr. Brooks, I am also holding you without bond for a period of 10 days to determine if Bay County is going to move for a revocation of or for a warrant for violation of probation for your fleeing or attempting to elude charge in Bay County. Questions about that, sir?
Judge,
All
just
right.
let the clerk know the fine for this offense is $400, not $370.
Is that accurate? All right. The fines will be $400 and those will be
He's an honest
reduced to
attorney.
a civil judgment. Mr. Brooks, I'm required to tell you that if you wish to appeal this court's judgment and sentence, you have 30 days within which to do so. If you cannot afford an attorney, one will be appointed to you for that purpose. Sir, we're going to need your fingerprints and I wish you well. What's the agreement regarding adjudication? Withhold or adjudication?
Adjudicated.
Is that the agreement, Mr.?
Yeah.
All right.
Yes, Your Honor.
Adjudicated guilty of the offense. All right.
There we go.
And it is the second degree. I didn't see any others.
Fair enough.
Mary Stevens.
Good morning, ma'am. Who do we have?
Mary Stevens, case number 24658CT.
I think this judge is filling
Ms.
in
Stevens,
today.
hello. Ms. Stevens, tell me your full name for the record, please.
Mary Elizabeth Stevens.
Ms. Stevens, did you understand the rights that were explained to you during the first appearance video?
Yes, ma'am.
All right, listen carefully to your attorney.
Your Honor, I spoke with Ms. Stevens and she's going to enter a plea of no contest to DUI with property damage with the understanding she'll be placed on probation for 11 months, 29 days. She will pay a fine of $1,078. She'll take substance abuse classes. She will have 50 hours of community service. There'll be a minimum driver's license suspension. She has signed a plea waiver form waiving the right to a jury trial, and we're going to reserve on restitution if anything might be owed to the victims beyond the insurance. I think the insurance should cover it all, but we'll reserve on it just in case.
Is that the agreement with the state?
It is, Your Honor, and this will be a withhold. It's first offense.
All right, fair enough. Ms. Stevens, if you will, please raise your right hand.
Can I just ask one thing? Or
Yes, ma'am.
Raise your hand. Raise your hand first.
Okay.
Hang on.
Okay. Sorry.
All right. Mr. McDaniel, our probation office is indicating to me that there is no withhold allowed on a DUI
Oh, yeah, that's right.
because
Great.
it's a
I'm
DUI.
sorry.
Is that what you understand as well?
That's my understanding as well, and I apologize.
Do you need a
Thank
minute
you.
to talk to Ms. Stevens?
No, because that's something I didn't even discuss with her. Because DUIs are all adjudicated guilty, and
I was mistaken on that.
It's all right. That happens. It's fine. No, listen, no problem, y'all. I mean, that's why we're all here together.
She's like, can I put my hand
All
down?
right. All right. So, Ms. Stevens, did she have a question, Mr. McDaniel, or no?
I didn't know if you want to swear in first. I know you were in the process of doing it.
Sure, fair enough. Ms. Stevens, do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
What's your question?
Thank you. You can put your hand down.
I just wanted, it's not really a question. I just wanted to put it on record that I'm going to try to get into a rehab. So it was like is anybody like the probation or whatever?
No, I talked to you about this before. I mean, if you want to, all you gotta do is go over there. If you want to go to rehab, you go talk to them. Go talk to whoever you want to talk to. And if you want me to try to get a rehab sentence, then you're going to sit in jail for another few weeks. But okay, so
go to the probation.
No.
So Ms. Stevens, I think what Mr. McDaniel is trying to tell you is this, okay? As part of the terms of your probation, you will be ordered, if you decide you want to take this plea, you will be ordered to complete substance abuse counseling, okay? The terms of the probation require substance abuse counseling outpatient, but if you wish to go to an inpatient facility, you may do so, okay? You may communicate with your county probation officer and they will work with you and try to help find you a place. And then that can satisfy the conditions of your probation, okay?
Yes,
but we are not pleading you to inpatient at this time.
Yes, ma'am.
Now, is there a DUI school that's required and all that? I didn't hear that.
there is a DUI school in about, I apologize.
Do I have to, I need to announce that, right? DUI school?
Correct. Yes, Your Honor.
Fair enough. All right. Anything else, guys?
Nothing but say.
Okay. Ms. Stevens, did that answer your question about whether or not you could go to an inpatient facility while you were on probation?
Answer your question.
Yes, ma'am.
All right. So Ms. Stevens, I find that, let me ask you this. Has anyone promised you anything other than what Mr. McDaniel announced to me regarding this plea to get you to enter this plea?
No, ma'am.
Is anyone threatening you?
No, ma'am.
Ms. Stevens, do you understand that by entering into a plea today, you are giving up your right to go to a trial where the state has to prove that you committed this offense?
Yes, ma'am.
Do you understand you are giving up your right to present any defenses that you may have?
Yes, ma'am.
And do you understand that you're giving up your right to appeal anything except an illegal sentence by this court?
Yes, ma'am.
Yeah, so Ms. Stevens, basically what I just asked is, when you enter a plea, the only thing that you can appeal is if I sentence you to something that the law doesn't allow me to sentence you to. And so that was what I was asking. Do you understand that the only thing you'll be able to appeal is that? Okay.
Yes,
Ms. Stevens, are you doing this of your own free will?
Yes, ma'am.
All right. And this is the agreement with the state?
It is.
Does the defense stipulate to a factual basis for purposes of the plea?
Yes, Your Honor.
All right. Ms. Stevens, I find that your plea is knowingly and voluntarily entered into after the advice of counsel. Do we now have a case number on Ms. Stevens's case?
24658 CT.
24 CT 658. Thank you. Ms. Stevens, in Jackson County case number 24 CT 658, I accept your plea of no contest to one misdemeanor offense of driving while under the influence with property damage. I sentence you to serve 11 months, 29 days county probation. During that time, I order you to pay court costs, fines, and fees in the amount of $1,078. I will reserve on the issue of restitution. I order you to enter and successfully complete a substance abuse program. I order you to enroll within 30 days of your release. Ms. Stevens, if you wish to participate in a substance abuse program inpatient, you may do so, and that will satisfy the requirement if you successfully complete an inpatient program. Ms. Stevens, it's important that you understand there will be zero tolerance for the use of drugs or alcohol while you are on supervision, and you will be subject to random urinalysis at your own expense. Ms. Stevens, I order you to serve 50 hours of community service work at a rate of at least 8 hours per month. I order that the the statutory driver's license suspension be imposed. However, the court has no objection to a hardship license being awarded should the Department of Motor Vehicles find that to be appropriate. I will adjudicate you to be guilty of the underlying charge and order that you enter and successfully complete DUI school. Ms. Stevens, do you have any questions for me about the sentence that I have just imposed?
No, ma'am.
Is there anything further from either the state or the defense on that matter? All right, Ms. Stevens, I am required to tell you that if you wish to appeal this court's judgment and sentence, you have 30 days within which to do so.
Okay, we're going to bail for this just for a second.
One will be appointed to you for that purpose. I got a call from Ruth. Ms. Stevens, good luck to you. We're going to need your fingerprints, but before you step away, listen carefully to the instructions from state probation.
Okay, we're not going to listen to her instructions for state probation. Here's what I'm going to do. I'm going to turn the camera black. It's going to be a spinny wheel for just a second. I'm shutting off the feed and then restarting it without killing the live stream. I'm changing one of the settings. We're hearing that a lot of people have. I did make a change to how it's broadcasting today, so I'm going to fix that right now. So everyone just hold your breath. Well, maybe don't hold your breath, but just hold tight. We're going to turn this camera off and change the setting and turn it back on. In 3, 2. All right, are we back? Are we back? Are we back? Is it any better? Did the blurriness go away? Check on this end. Now I think it's blurrier. Okay. Third tries the charm. 1, 2, 3. See, the concern I have right here, welcome back. We made it last time. I'm not going to change it anymore. The concern I have is that on my end, it shows that I'm only sending a data rate of 0.13 megabits per second, which is low, very low, like a tenth of what I normally send. Looks good to you all? Might reach out to YouTube and say, what is up? Okay. If it looks good on your end, free eye test, Alicia. Yes, free eye test today only. Crystal clear. All right, we'll leave it like that. I wonder if those that are struggling with the connection, YouTube might have changed something. You went to 240p. That's what I'm wondering. Check your settings. If you can go to the settings, even on a Roku, on a Apple TV, on any device, if you click the little gear in the corner, you should be able to check the stream quality settings and select 1080 usually. 1080 will give you that's what I'm broadcasting in, and that's a crystal clear image. But you have to have pretty good internet to keep that going. YouTube has been downgrading it. It's like they're trying to save money. Man. Fun fact, my hubs named our Wi-Fi here Black Hole. He's a science geek. I named mine FBI Surveillance Van. 1080p, I can count your stubble. I was going to use the live stream to shave. So, Starlink is awesome. I'm looking at a Starlink Mini for the LiveView kit. If we can add a Starlink Mini to it in addition, that might be the best. All right, let's jump back to court here.
No, ma'am. Is there anything further from either the state or the defense?
No, Your Honor.
No, Your Honor.
All right, Ms. Whitman. I'm required to tell you that if you wish to appeal this court's judgment and sentence, you have 30 days within which to do so. If you cannot afford an attorney, one will be appointed to you for that purpose. Good luck to you, ma'am.
Thank you.
Donald Ash, case number 21435 MM.
Mr. Ash, good morning.
Good morning, ma'am.
He's a tall man.
Mr. Ash, tell me your full name for the record, please.
Donald Darrell Ash.
Excellent. Mr. Ash, did you understand the rights that were explained to you on your first appearance video?
Yes, ma'am.
Great. Mr. Ash, you are being held at this time for allegedly failing to appear for your arraignment in Jackson County case number 21MM435.
Allegedly failing to appear.
Judge Mercer had signed a no bond warrant.
The
on
judge
that
is there
case.
and sees if
Mr.
you appear or
McDaniel?
not.
Your Honor, generally on these cases, he used to do no bonds, but we corrected it and, tried to start following the law a few years ago and actually put bonds on them when they don't appear. So he would be entitled to a bond, but I don't know if the court or the state wants to entertain a motion to dismiss it for statute of limitations. And I talked to Jake. I had never got an answer. I'm not sure if he wants to do that or not.
Let me ask you this. Are you suggesting that the court cannot hold without bond on an FTA?
Well, he's never been served with it, Your Honor. So they only mailed him a copy of a complaint. So he's never been served with it. So,
Got you. So that's the issue because there was never actual service.
John, would you be all right with me reading the email you sent to me to the judge?
Sure. That's fine.
Okay. So, yeah, he sent me an email about... I'll try not to. He sent me an email this morning just basically saying that, he's listening to what he just said. Statutes of limitations has run. He's been in Florida this entire time, has been on probation, arrested several times, appeared at hearings in Gadsden for 2439 MM from 9/21 until 10/22, placed on probation, BOP in 12 of 22. Arrested and pled January of 2024 to time served. If you want to, I asked Judge Garcia to look at it. If you don't object, ask her to dismiss the case.
So the defense has made a motion to dismiss the action for as barred by the statute of limitations. Is that accurate?
Correct, Your Honor.
And what's the state's position?
We'll leave it up to the court.
So the state has no objection?
The state has no objection.
Motion granted. Anything else you would like to address at this time?
Nothing else, Your Honor.
All right. Thank you very much. The case will be dismissed.
Wow.
We'll be in recess. Thank you, guys.
And now we're in recess. Recess time. Dibs on the monkey bars. Let's see. Down in Florida, that was a fill-in judge, and crazy. Come on, Judge Middleton, are you there? I was hoping the judge here would give us just some nuggets of wisdom. Sometimes he pontificates. He pontificates when he's on his own, and just shares interesting, fun stories. He seems more contemplative today. Is your favorite chalkboard? How many courts do you normally see that have a chalkboard anymore? I mean, whiteboard, I can see that. Poster board, but chalkboard, a true chalkboard. Just some motorcycle stories. I just want to hear like where he went riding around Michigan.
All right, well, we've got Enchanted Glen. We don't yet have Mr. Spiel or Ms. Bauer, so we'll continue to wait.
Some of his killing time moments.
Looking at some emails. We have a lot going on. A new prosecutor has to be sworn in. All the assistants need to get sworn in. A new sheriff needs to be sworn in, and all of his deputies. There's a new judge who needs to be sworn in. The other two judges were also just reelected for 6-year terms. They need to be sworn in.
Could be a lot of swearing.
There's a procedure called an investiture where the new judge accepts the office. So that needs to be done. And they're apparently planning some sort of retirement for Judge Tomlinson. So there's a lot going on between now and the end of the year. And you need to make sure that all those things are done before January 1st. There was a problem a few years ago with one of the elected offices where the elected official didn't show up for work on January 2nd, and none of the deputies have been sworn in and had the authority to do anything. But I'm sure we won't end up in that circumstance. Anyway, new county clerk, new sheriff, new undersheriff, new prosecutor, new judge, new judicial secretary.
We'll have a lot of new faces in court.
More
Is what you're
things
saying.
changed, or they stay the same.
A little wisdom there.
There's Tom Petty says things change and they change again.
Bingo on the Tom Petty. I'm looking, I don't know which one EDB has, but I'm looking at a vocal effects processor to change my voice for prank calls.
Well, we have 11 more minutes to tick. I guess 6 more.
One is enough.
3 Enchanted Glen. A termination case, and then there's a damage hearing, I think, at 11.
This particular box, multi-effects vocal processor, it makes my voice deeper, which is probably not going to be good. I could go robot or I could go child. Child won't work for any of our Medicare prank calls. But I could do an octave jump higher. And it's also got pitch correction, which might be good for you because it means that I'll always be on tune when I'm singing happy birthday. Let's see how it would connect. Not sure how it would integrate into my system. I could do it, but it would be weird. I don't like running my processor, my voice through a bunch of systems that aren't processing it because it's just another point of failure. Voice transformer, here's another one.
Well, I guess no one's going to be here early.
So we're here, Judge.
When they get here. We have 5 more matters to address. Somebody drove all the way over from Hillsdale County to sit in on this.
He's talking to his chat.
It is a beautiful morning. With the visitors we had from St. Paul, there are more leaves still on the trees here than there. So once they got around Chicago and got into Michigan, it was a beautiful sunny day yesterday and a beautiful starry night. Anyway, they enjoyed the drive, but then they were going to go on and visit a couple other courts.
It would be fun to go up and see Judge Simpson.
That's where they were going. They were going to go see Judge Oakley, and then they were going to go see Judge Simpson, or I don't think Simpson, then Oakley. I'm not sure. Anyway, they were very nice I had a nice time talking to them.
Just tourists coming through, checking out their judges. Oakley. I thought he was in Florida. Why? Oakley's the one who stands, right? Am I getting the judges right? PJ, I don't know what YouTube changed.
Ms. Bauer emailed me first thing this morning.
We're pushing high quality. A lot of people, it's working great for you. You might have to go in your settings and adjust it. Change it to be 1080 or 1060 if you're international.
He was going to be working with Attorney Spiegel. And
judicial tourism.
So
sort of
I'm not sure. They must be working in earnest because that was.
It's like court watch, but with
45
autographs.
minutes ago.
I wonder if we could talk to the judges and sell them on designing their own travel stamp for True Court passports, so that each judge can stamp your passport to say I've been in Judge Simpson's court, I've been in Judge Boyd's court down in Texas. A travel passport with unique stamps for each judge. I think it would be a hit. And then we could do cruises, land cruises. We'd rent a huge Greyhound bus, and it would be party in the bus, big screen up front, watching court on the drive, and then we all file into court respectfully, and get our passport stamped with the judge. Quick photo session, and then on to the next court. The local sheriff can arrange that. I don't want them to do the arrangements because their booking process is not what I have in mind for booking. Hey, Josie Brown, Mariah Hayes. Oh, we got people here. Enchanted Glen, welcome.
Good morning. I brought everyone in. We've got 3 Enchanted Glen cases, and I've yet to see counsel. Jesse Brown and Mariah Hayes are here. The manager, Kim Shaw, is here. I believe Mr. Spiegel and Ms. Bauer from Legal Aid are working on these cases right now. So I'll just check in to let you know that I'm ready to go as soon as they are, and I'm going to put you back in the waiting room while we wait. So anyway, I didn't forget you. And I'm waiting for them, and then I'll bring you back, okay?
All right.
I'm just sitting here thinking deep thoughts.
Contemplating wonders of the universe.
Yes. There's a theory that whales sit there under the sea and think very deep, ponderous
this is what I'm here for.
Thoughts about the nature of the universe.
Mm-hmm.
So that's a worthy enterprise.
So we're going to be whales today. Does everyone mimic their whale, like Dory the whale? Doesn't Dory speak whale?
Maybe it's good news that they worked hard and resolved all these, or maybe they're still at loggerheads.
But Dory speaks whale in the.
Which is also the name of
in the Finding Nemo movie.
Beachfront bar in Key West, at the north end of Simonton Street. It's about 40 feet wide.
It's like there's a microbrewery that just opened in Hillsdale. It's called Big Pines, and it's smaller than your courtroom.
Do they have more than one, or is that the first one they have in town?
Hillsdale Brewing has been in business since 2018. I actually saw Keith down there. He was there for a bar meeting. It was kind of funny. He's like, I had to do a double take. It's like,
Yeah, he does a lot of work in Hillsdale County.
Okay, that's funny that a lawyer, he ran into a
Almost
lawyer
every
at a
town of any
microbrewery.
size
It was a bar meeting.
has a microbrewery, which is the way it was 100 years ago. They didn't have refrigeration, and every little town had their own brewery, and the breweries are regional. Even little towns like Seaboing, Michigan had a brewery, and Kalamazoo and South Bend had Blatz and Frankenmuth. Anyway, refrigeration came and brewing went regional and then national. Now it's back to every little town has their own little brewery.
well, Hillsdale Brewing's a unique situation because it was built in the late 1860s. The building was the original building.
They're asking you to hold that hearing. I guess there was some conflicting.
Yeah, they can log in.
And I guess the property manager was logged in and didn't get invited in or something.
I never saw her.
Okay.
But yes, they can log in. I wondered why no one showed up.
Okay, I'll let them know.
All right, the clock is ticking. Miss Anzaldúa is here with us now. Meg Bauer will be joining us, which is probably a sign that Mr. Spiegel will be joining us. Also, someone was going to come in on the Elaine, I don't have that case. I don't know what I did with it. The St. Joe River case. I don't actually have that file. I don't know where it is. I don't think I left it anywhere. Good morning, Mr. Bradshaw.
Good morning, Your Honor. My sincere apologies. This did not get on our calendar for some reason. I think I know why, but that's not your concern.
Well, I knew it was on the calendar, but I don't have the file. So,
well, maybe that helps because we show that it was at two different times, and anyway, it just got dropped on our end. So you're waiting for a file on your end?
All right, yes.
That would be helpful.
And I've got some, well, let me call it. It's entitled Limited Development Housing Association, LDHA.
Forgot to give the internet to Cheryl. Congratulations, Cheryl. The internet's all yours. First in chat.
It's Edgewater Apartments versus Janelle Anthony. It was filed as an emergency termination of tenancy. Janelle Anthony was also charged with some criminal charges, fairly serious ones, as a result of some things that happened at the apartment complex. In the context of the criminal case, then we had a very difficult time with her, trying to get her arraigned. And
as you can see in my file, I actually gave notice and a request for an immediate order of eviction, given the activity that has been taking place at the property, including the illegal use of narcotics and physical assaults against other individuals.
Yeah,
she's charged with assaulting another tenant and breaking their collarbone. And anyway, she was seriously mentally ill.
case I already took.
Oh, all right, it got connected to something else.
Meg, you're not
She
muted.
was ordered to have a competency evaluation. Then she bonded out. I don't know who bonded her out. I don't know their name. Anyway, someone bonded her out. And her mother had petitioned that she be hospitalized. So she was hospitalized, and she's hospitalized now. She did call the court the other day to apologize to me and had some other things to say, which would lead us to believe she's still suffering from some mental health problems. So now everybody's shown up on Edgewater. So, Janet Glenn, but we'll take care of this first. At any rate, this is a request for an emergency writ of eviction because of the issues that we discussed. However, the defendant isn't competent. Although, and I saw it myself, I've known Miss Anthony since she was in high school. I tried to engage with her, and then the wheels fell off, and it didn't go well, and she was removed, and she's got criminal cases pending, and she is hospitalized. I'm sorry, sir. You were here before, and I thought you were here on Mr. Wardell.
I'm sorry, Judge.
So go ahead. Give me your name again, because you're logged in as Shana Anderson.
Daniel Artley, A-R-T-L-E-Y.
We're going to fix your name for you, Mr. Artley. So you're not Shanna anymore.
And you're with Edgewater?
Yes, sir.
All right.
There we go. I got it, Judge.
You were here, but I didn't realize what you were here for. So that's why I removed you when the other, I thought you were on Mr. Wardell. All right. I gave some of the background. Ms. Anthony is currently hospitalized pending a competency evaluation on the criminal charges. Is her property still at the complex?
Yes, it is.
But she is not.
True. Correct.
In fact, I think she has a bond condition that may prevent her from going there. Mr. Bradshaw, I'm not sure what our authority is to evict someone that lacks competency. What's your position here?
My position is that the only issue we have is she's, if she's in default, I may not ask for an immediate, because I think you might want to give her an opportunity to give her an opportunity to vacate. I think the fact that she's incompetent does not save her from being able to engage in the behavior, including the use of illegal drugs on the premises. I don't think that's going to be a defense to our eviction. If you wanted to give her some more time to have her family remove her, we don't need a judgment. If you wanted to give her family time items, that'd be fine.
She was personally served. Her mother did file the petition for hospitalization, which is where she's hospitalized right now. 10 days from today would be the 18th of November, which would be the 10-day default date. Is that sufficient?
I believe it is, as long as she's not going to be coming on the property pursuant to her bond.
Mr. Artley, do you have contact with her mother?
Yes, I've spoken with her.
Sam, do you believe it's going to be fine if we give them the mom that's an opportunity to try to remove her belongings? Oh, Dan.
Mr. Hartley?
Sorry, Dan.
Oh, okay. I'm sorry. I didn't know who you were talking to. Say it again, sir.
Do you think that's okay to give her the 10 days? I think that's fair to give her the 10 days to let her mom try to remove her items.
Yes, that would be okay.
All right, but you don't wish a judgment at this point?
I guess I would, if you're, here's the problem with doing a conditional dismissal. I'm all in favor of doing a conditional dismissal.
I would rather do a judgment.
Okay, sounds good. I'll do a judgment.
Do a default judgment with the date of November 18th.
Okay. I don't like the way the 302 is written, but it is what it is. If she's not here to agree, we can't do a CD. So.
Correct. She, as I said, I've known her since she was a high school student. She was in acute distress when I saw her. Hopefully they can get her stabilized, although the crimes charged are pretty serious ones. And I don't know where she is. I could find out from the probate court, but I don't know where she is.
Judge?
At any rate, yes?
Oh, I'm sorry. Excuse me, Your Honor. Is it right if I speak?
Yes.
She did try to call. She called Janelle. She called the office. And she said herself, I didn't catch the call, but she left a voicemail. And she said she's in Battle Creek, psychiatric ward in Battle Creek. And she also said that she was trying to get Riverside Church to help her move her stuff out. They never called the office. And then she called again and said that now she's trying to get somebody else. I couldn't understand what she was saying on the voicemail.
All right. Well, let's see if we can get her stuff moved to somewhere secure within the next 10 days. Okay. All right. Thank you.
Thank you. I'm going to get to the court again. I apologize for tardiness.
All right. Well, there was some confusion. What I did is I clipped the file to another case and set it there, and then files were removed and that one was taken out as well. All right. You guys are good to go. We'll go back to Enchanted Glen and deal with those.
I'll call you, Dan.
Okay. Thank you so much.
Good morning, Your Honor.
Good morning. We've kind of been in a holding pattern. That case was late, but we did address it. We have 3 Enchanted Glen cases. Nicholas Spiegel is here. Nicole Anzaldua is here. And I don't know, Mr. Silver is here. But I think Mr. Spiegel and Ms. Bauer have been working on these cases through the morning here. So let's start with the first one that's scheduled, which is Enchanted Glen versus Miriam Hayes and Matthew Brown, Jesse Brown. Good morning, Mr. Spiegel. What's the status here?
So yes, I've had a chance to talk to Ms. Bauer. It's my understanding, I don't know if it's been entered yet, but she's going to be appearing on both this one and the Seiler matter. And we had some discussion about both those files. We'll keep it to Hayes for now. My understanding from talking to Ms. Bauer is she has a copy of a ledger that's a little different than mine. We need to kind of compare notes and see where those differences are coming from. There's also a request by them to kind of enter into some kind of repayment plan over the next couple months. So I think at this point, what makes sense after talking to her is maybe we set this out a trial date, 2 or 3 weeks, and we continue to have discussions in the meantime and see if we can, bridge that gap and figure out exactly what the differences are, and with the eye toward probably entering into a conditional dismissal type of agreement. Is what we're looking at, assuming we can come to a mutually satisfactory conclusion.
Ms. Bauer, what's your position?
Judge, that's a pretty accurate summary of the conversations that Attorney Spiegel and I have had. There's some questions about the validity of the demand for possession that was served. There are some questions about the rental rate and the amount of the rental subsidy. At the end of the day, the lease, the rental rate stated in the lease doesn't match what's in the complaint or what's in the on the ledger, and there is this ongoing issue about the portal being inaccessible, although we understand there are other ways for rent to be paid. And at the end of the day, if Attorney Spiegel and I can come to terms, or Attorney Spiegel and I believe we can come to terms on what the actual or proper rental rate is and the total amount due, and that the tenants will be able to enter a repayment plan that is agreeable to the plaintiff and have this matter resolved cordially and as efficiently as possible for the plaintiff.
Well, when we were here last week, there was $1,116 floating around somewhere. Was that actually paid toward the rent?
That is the other case, Your Honor.
That's not this case?
No, Your Honor, that one, yeah, as a reminder, Ms. Seiler said she had several money orders that hadn't been cashed, and I think you heard me tell my client they needed to cash.
Well, I may have conflated my notes here. I thought the Brown and Hayes said they tried to pay from the portal and the portal wouldn't accept it. And
they may have made that representation. I won't say that they didn't. I will simply say that one, as opposed to the other one, no actual checks, money orders, or anything else was in my client's hands. My direction, I think, if you remember, to the client was, well, if the portal won't take it, you make sure the office is open to take it. And my understanding from my client is that no further attempts to pay anything have happened in the last couple of weeks since we were here. So,
and Your Honor, I see where your notes came from. Your Honor.
Yes, just a minute.
There was this discussion about a payment by the tenants for $1,116 and the timing of when that payment was made. There was a $400 balance remaining on the account right after that transaction was made. The very next day, the tenants attempted to pay the remaining $400 balance, but they were locked out of the portal. That lockout happened in between those two dates, but the plaintiff has credited the ledger for that $1,116. And Attorney Spiegel's representation is correct that they have not gone into the office to make another payment there. So apologies for misspeaking a little bit.
Well, I have Wednesday, November 20th as a jury day, and there's no jury that day. Someone's blocked my calendar from 8 to noon for a potential building meeting and from 1 to 5 for a potential building meeting. I'm not going to block out my entire day. Can we continue this to 9 a.m.?
Judge, I will be out of town that day.
All right. How about 1 a.m. that day? Will that work?
If I can find internet, I can do it. But I won't have signal.
I assume at 1 p.m., Your Honor?
Yes. How about 1 p.m. Wednesday, December 4th?
December 4. That looks clear on mine.
Same.
And that should give us plenty of time to get down to the bottom of this one way or the other.
And I'm confident that this will resolve. Of course, November's rent will be due also.
And
probably set each of these cases for that same date.
Riverview has an interesting
All right, Ms.
backdrop.
Shaw, I understand you're new to this. You inherited some of this from your predecessor, Jen. And so they're going to need to work with you to try to reconcile the ledgers. And there's some discussion of a repayment plan to get caught up. You're not obligated to do that, but you have the right to do it. So we're going to continue this to December 4th at 1 o'clock. I have a jury trial set that morning that I don't think is going to go, so I'm double booking myself, but I think I'm going to be okay.
Just to be clear, Your Honor, that would be a trial date, not just a continuation.
Yes.
Okay, perfect. Thank you.
If it's resolved, great. If it isn't, we'll figure it out.
Perfect.
All right, Ms. Brown and Mr. Hayes, Mr. Brown and Ms. Hayes, you're good to go. I'll remove you. Stay in contact with your attorney at legal aid and your manager.
All right.
Thank you. All right, Ms. Anzaldua, let's talk about your case. This is Enchanted Glen versus Nicole Anseldua. Again, we were here last Friday, November 1st. The matter was continued. Rent was determined to be $3,074, $259.14 in court costs for a total of $3,332.14. Mr. Spiegel, what's the status here?
And so this one, actually, Your Honor, has largely been paid down. It sounds like Ms. Anseldua has been able to pay everything except for those $259.14 of court costs. So that's really all that's left, although my understanding is Ms. Anseldua is kind of in a tough spot with employment. Site manager, Ken, this morning. And it sounds like what we're willing to do is give her a little extra time to get caught up on that, recognizing she did make a pretty large payment on this. So they're willing, of course they don't have to, but they're willing to extend the writ date till December 30 to try and get that caught up. Is that right?
My big gig is on a
Is
week from
that
Sunday.
correct, Ms. Shaw?
Yes, it is. Yes.
November 30.
I'm sorry, December 30. They're actually going to get around.
December 30. All right. Well, good. So is her rent now at zero?
I don't think her rent's at zero. So of course, I mean, you know, she'll have to pay December's rent when it comes due. But
yeah, rent's $175.
Yeah.
All right, Ms. Anseldua, they're going to agree to that you owe $259.14 due by December 30th, plus December's rent. Is that acceptable to you?
Yes.
All right. All right. And Mr. Spiegel, would you send me a judgment to that effect?
We will do so, Your Honor.
On the comment line, we'll put, in addition, December's rent shall be due. Ms. Anseldua, do you have any questions?
No.
All right, thank you. And sounds like you're doing pretty good. Hopefully you can get this caught up, get the cost paid, get December's rent paid. You'll be good to go at the first of the year.
Okay.
Thank you.
Thank you.
All right, let me bring Miss Seiler in. She fell over or something.
Welcome back, ma'am. I think it was just the phone that fell.
Miss Seiler, can you hear me?
Yeah.
It's terrible audio on our end.
All right, we had some trouble, I think, last week with the audio too.
Yeah. Yeah.
I don't know. Have you got something else on there?
No, I could hear you fine, and then my phone fell, and now it's like you're breaking up.
All right, well.
You get a pass.
We'll hope for the best.
No, Judge, it's going to kill our ears.
This is also a claim for non-payment of rent. Through November, it was $2,618, $289.14 in cost for a total of $2,877.14. Mr. Spiegel and Ms. Bauer have been working on this case through the morning here. Mr. Spiegel, I'll defer to you. What's the status here?
So this was, as I mentioned, one where there were several money orders that my client was holding. And of course, we discussed last time that those should be applied. Those were apparently all successfully applied. $1,400 worth of money orders were credited toward the account. That left a balance on, as far as I have, $1,477.14 inclusive of costs. I think, again, Ms. Bauer had slightly different ledger. So we had to try and reconcile that a little bit. It's also my understanding from Ms. Bauer, I'm not sure if the form's been submitted, that Ms. Seiler has applied for aid. And so I think she's entitled to a kick of certain time to an adjourned hearing in any event, if that's the case.
What if we continue this one also to December 4th? Is that acceptable? I'm going to set it at the same time.
Is that fine, Meg?
That was my anticipation, yes. So that works for me.
All right, Ms. Seiler, there's a dispute about how much you owe. You made a good faith payment of $1,400. We're going to continue this to December 4th. So in the meantime, December's rent is also going to be due. And rent here is $265 per month. So we will deal with this at 9 o'clock on December 4th. Now, in the meantime, if your lawyer and legal aid and your manager can come to a solution and agree on how much is due and owing, they could perhaps submit a conditional order of dismissal or even dismiss the matter if it's all paid. But unless it is resolved, I will see you by Zoom like this once again on Wednesday. That's an unusual landlord-tenant day, but I've got time that day. And I've got both of these attorneys there that morning. So Wednesday, December 4th at 9 a.m. Is that?
Judge, I had us at 1 p.m. on our last discussion. Did I miss that?
No, I thought I said 9 a.m. So let me look.
I think there's a discussion on earlier.
No, I did say 1 p.m. 1 p.m.
1 p.m. Okay. That's
well, I don't, I've got a security committee meeting that day. Does 9 a.m. work?
Either one works.
All right, let's do 9 a.m. I got nominated to be chairman of the security committee. We have a large meeting that day and we're going to do lunch. So let's do December 4th at 9 a.m.
Judge, you'd like to move the other case as well, I presume then.
Yes, I'll move both of them to 9 a.m. Now let me look at that again, make sure I'm not losing my marbles. No, it's correct. It's 1 p.m. That's the day that I have a jury trial. So we'll do both of these at 1 p.m. I'm sorry, I once again conflated my two cases. All right, 1 p.m. on December 4th.
Sounds good.
All right. Thank you all. Thank you. I'm sorry for the confusion.
No problem. Thank you, Your Honor.
Thank you.
All right, I believe that resolves
Mr.
all
John,
of the Enchanted Glen cases.
live from the air traffic
Ms.
control
Bauer,
tower.
one of the defendants, Mr. Rosario, we went through that whole rigmarole where his apartment was restored. He hasn't paid his rent since July, and they're asking for non-payment of rent. He's claiming something. He's claiming there's a dip in the floor, and that is why he hasn't paid his rent, but that isn't really why. He just doesn't have any money. He wanted to speak with you, and I told him you were unavailable, so I directed that he call you.
Thank you for the update, Judge. We have been trying to schedule him for an appointment.
All right. From what it sounded like to me, he didn't have much of a defense. If it does get continued, there's going to be a escrow order, but they were somewhat frustrated with him. So, all right, I did tell him to give you a call. All right, well, let's go to our next case. We have two more to do. This is Eric Pearson versus Keisha Roberts. Mr. John Bush is here on behalf of Mr. Pearson. Ms. Seiler, I'm going to remove you here so you can go on with your business.
Now, where do
John
I go,
Bush
Judge?
is here, Ms. Roberts is here, and Mr. Pearson is here. This was filed as a termination of tenancy. Rent has not been paid here since March. They're not at this point asking for payment of rent. They're simply asking the defendant to move. She's been there for 7 years. She's dissatisfied with the condition of the premises. And I thought perhaps she should just move. Ms. Roberts, what's your position? Are you still there?
Yeah, I'm still here. My only request, I was really going to request if I could have just a couple more days than 10 days, maybe 14 even. And if there was any way, because I did just have a baby on the 17th of March. And that kind of, before that, I wasn't really getting a lot of packing done because I was right towards the end of my pregnancy. So I kind of needed just a couple more days if that's all I could get.
Well, let's talk about that. The date for the writ, if we use the normal thing, would be 10 days from today, which would be November the 18th. Mr. Bush and Mr. Pearson, are you willing to give her some additional time to vacate, like till November 25th?
I would be happy to, Your Honor.
That's fine, Judge.
Is that enough time for you, Ms. Roberts?
Yeah, I can definitely make that work. Definitely better than the 10 days. Just because I just got recovered. I'm still in recovery too from pregnancy. I'm still on my maternity time, but.
We're fine with the
March.
Judge.
All right. And even though you've been there for a long time, I think it's time to move on to another place for many of the reasons that you stated. If you do move, you need to turn in your keys and give your forwarding address in writing within 4 days. So Mr. Bush, I don't know. Oh, I do have a judgment here.
We sent one, I believe, yesterday.
Yeah, you do. I'll show a consent. Defendant agrees to vacate. We'll have to.
Your Honor, I do have.
Sure, go ahead.
I do have one more request. I've had several complaints from other residences in the apartment building about them. They don't want to expose the baby to smoke, so they've been smoking in the hall and the laundry room and around the exit door, which is right near them. And I would appreciate it if they would go smoke in their cars or around their cars or something and just make it more comfortable for the other tenants to come and go.
Okay, yes, I can definitely do that.
Only one person.
All right, the defendant agrees to vacate by November 25th, 2024. The date for the appeal is still November 18th. As I indicated, when you move, you need to turn in your keys and give your forwarding address in writing within 4 days of your moving. Now, this is a consent where you're agreeing to move, and we put the consent on the record. There's a court rule, Michigan .4201, which talks to that. I want to quote it accurately. I haven't used it in a while. Oh, they don't have the 400s in here. Criminal book.
Judge is hitting the books.
I feel like a kid who's suddenly there's a chance to pitch in the World Series or doing the game or the King of the United States. I want to be king. I'm running only as a perfect storm. Perfection.
Hot mic.
All they can do is time. They can never move.
When you consent, the judgment may not be enforced till 3 regular business days have passed, and I shall review the judgment. If you're not represented by an attorney, which you are, you may move to set this judgment aside within that 3D period if you misunderstood what we just did, or you disagree with it. And then if that happens, the court would set aside the consent judgment and set it for further hearing. But at this point, you're agreeing to move by the 25th of November. If you don't move, you would be subject to being evicted. You understand?
Yes.
And again, you need to turn in your keys or give your forwarding address in writing within 4 days of your moving.
Okay.
And we'll send you this. Now, I'm not ordering that you pay anything. Not at this point. If there's going to be a hearing regarding money damages, that would be at a later hearing. This is simply an order for possession. And that's part of why you need to give your forwarding address in case they pursue other money damages. All right, good luck.
Thank you, Judge.
All right, thank you.
Thank you, Eric.
Thank you. Thank you, Your Honor.
Thank you. All right, I believe we're on our last case.
Who's our last person, Judge?
Meg, this is a hearing for money damages.
Okay. I am happy to get out of your hair. I'm also happy to continue to be here.
Let's see where we're going here.
Meg's a big fan. They're both wearing the same hairstyle today, which looks good. Let us bail for just a second. We have another court I want to jump in on. Let's see. Right here. And we're going to back up just to see what happened right here. Back to Kansas with Judge Webster. There she is. Hello, Your Honor. Good morning. How you doing?
Missy, are we ready to go on the record? Looks like we are on the record. This is our Friday, November 8th, Greenwood County traffic docket. We are on the record in the 13th Judicial District, the District Court of Greenwood County. First on our docket is case number 2024 TR 542, State of Kansas versus Jessica Jean Epting. Greenwood County Attorney, Assistant County Attorney Paul E. Dean appearing for the state. Is Miss Epting or anyone for her present?
Judge, she has been turned in Allen County.
All right.
Well, she's in custody.
Is her bondsman here? Would that be you, Mr. Jones?
No, ma'am.
All right. So she is in custody in Allen County. Who turned her in? The sheriff of Allen County?
I don't know. I just know she's on the jail sheet that says she's awaiting transport.
All right, Mr. Dean, how does the state wish to proceed on its motion for forfeiture of bond due to her failure to appear August 30th?
Well, Your Honor, I would quite honestly like to ask for forfeiture of the $10,000 bond, but I think since she is in custody, that there's probably case law that indicates that gives them a defense in this matter, and that is the point. But I would thought if I would have posted a $10,000 bond for somebody and received a certified mailer to be in court today about that matter, I would have been in court.
Absolutely. I would think that too. And we've been having some issues about that on a few cases in the county where they just don't think they need to show up. And then when forfeiture is granted, they get concerned. So do you want to maybe continue this or?
Your Honor, that's exactly what I'd like to do. I'd like to continue this to, let's go to probably our later January setting. And the reason why is I have asked the assistants in the county attorney's office to go through and start cataloging the bonds that we've received judgment on and have failed to be paid. I'd like to have that information in hand to see if they are owing us on any other bonds. And perhaps we need to set a hearing on this matter and all the others at the same time with them to address it.
The bond company might be in trouble.
Continue to Missy, the date in January that we have?
January 31st at 9 o'clock.
That should be great.
January 31st, 9 a.m. The matter is continued, and I presume we'll have her back from Allen County before then. So if there is nothing further on Epting, we will be in recess.
Okay, they go to recess, and we go somewhere else. We go right here to one of our new favorites. Judge Frazier. Good morning, Judge. Tech support there right behind him.
Our guys can hear us?
We can hear you, yes.
You can hear us better?
Yeah, it's good.
All right, so it looks like it's much better. Yeah, I don't know what happened. Okay. All right. Did you want to say something real quick? Yeah, no, Edna.
Yes, Your Honor. Oh, I'm sorry.
Edna, give me a second.
Yes, Your Honor, I have an arraignment.
Oh, I'm sorry.
I was doing his arraignment. Just give me a second. Let me.
Yes, Judge. I just wanted to reapproach on his bond conditions, Judge. I just met Mr. Bohana yesterday. I wasn't aware that he is actually a truck driver. He has a commercial driver's license. He's a family man. He has 2 children. I would ask the court to consider giving him an interlock device or whatever device the court deems okay to allow him to continue working.
Come up.
Judge for taking the time.
Sure.
Yeah.
Of course.
Yes, sir.
You are a licensed truck driver and have a CDL. You allegedly have alcohol in the car. You are held to a higher standard because you have a CDL. In fact, your breath tests are even lower than what a normal person is because of a CDL. And now you want me to just cut you some slack? Every person that comes in here, when they have alcohol in the car, I take away their ability to drive. Actions have consequences, and I understand that this is going to cost you big, but am I supposed to feel bad? Until I truly know that you appreciate the fact that the awesome privilege it is to be able to drive. I'm sorry. Show me that you understand and that you appreciate the ability to drive, and then I'll reconsider. But I have a real problem considering even that you have a CDL, you have alcohol in the car allegedly while you're driving. No. Take a seat for me. Show me some time that he appreciates it and not this, I feel better now. I'm like, no. Proactivity that he appreciates it. Come back and we can talk.
Yes, sir.
It's not a hard line, and I'm not, we're not out for blood forever. It's just, I want to know that he appreciates it. it's not going to be an issue ever again. And then, you know.
Yes, sir.
Okay.
Thank you, Judge.
For sure.
All right, Judge.
All right.
Page 8, Ibarra, come on up.
He takes protecting the public quite seriously. Ma'am, right here in the middle. Step right up.
Sí le contestan nada más en español.
Oriana Guevara Aponte.
¿Es usted?
Sí, señor.
Ma'am, you were charged with theft.
La cosa con hurto, robo.
You were facing up to 6 months in jail and or a $2,000 fine.
De $2,000.
We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Officers were dispatched to Walmart in Harris County, Texas, in response to a theft. The loss prevention officer told officers that the defendant placed numerous items into Walmart shopping bags that were already in her cart. The defendant continued to place additional items into the bags, including a blanket and plug-in sets. The defendant then walked past all points of sale without paying for the items. No prior criminal history, Judge. The DIMs don't say. I'm checking to see if the offense report is up.
Great to see you. Look.
We do have some discovery, and I'm just seeing if one of them is the offense.
Need a value.
I know. Okay, yes, $218.52.
Ms. Guevara, I'm going to find that there's probable cause to go forward with the case. Tell me, are you a United States citizen?
No.
Are you in this country with or without permission?
Sin permiso. With permission.
I don't know whether you do or not. Quite frankly, it doesn't matter. The only thing I will tell you is that if you are not, or if there's any problem with your paperwork and you go to jail and immigration finds you, they will put a detainer on you and you will be stuck in custody until this case is over with and then shipped off to immigration and sit there for another 6 to 9 months. If you do not want that to happen, do not violate any of the conditions that we put forth on you now and do not pick up a new case. I'm ordering you as a condition of your bond not to go to any Walmart for any reason whatsoever. Do you understand?
Yes, sir.
If I find that you go to Walmart, I'm going to revoke your bond, put you in jail. You will not get any more PR bonds. Now, you have an attorney. It is your responsibility to stay in touch with Ms. Garcia. She will tell you when you have to come back to court. If she tells me she can't get a hold of you, likewise, we will issue a warrant for your arrest. We will have you sign a reset with Victoria. After that, we'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and after that, you'll be free to go. Heed this warning, man. You will not get another one. Please. Thank you.
My competition.
Fight.
Judge, the next Spanish speaker is page 6, Jay Alvarado.
Jen Jams, just want to say thank you to our community. I've been going through some dark times. This gentleman can help lighten those darker times. Jen
Helen
Jams, thank you.
Tofila de Alvarado Mejia.
Apple Treasure member for 10 months. Jen Jams for 8. Congratulations to both of you. Jen, you're about to get a new color courthouse. Apple Treasure, you're not far from one as well.
You are Helen de Alvarado Mejia.
Yes.
Ma'am, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine.
Walmart?
We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Officers were dispatched to a JCPenney in Harris County, Texas in response to a theft. The loss prevention officer told officers that he observed the defendant take various items and walk past all points of sales without paying. The officer observed this on the store surveillance. The total cost of the stolen items was $178, and the items included a smartwatch and skin products. The co-defendant in the case was arrested for possession of a controlled substance out of the same transaction, and she's up in felony courts, and this defendant has no prior criminal history.
Did the other person have a theft case as well? Do you know? Or just a PCS? Because if they also charged the co-defendant with theft, we need to know what the cause number is, because it may
It
transfer.
was just a PCS, Judge.
That's it? Okay. Mr. Alvarado, I'm going to find that there's probable cause to go forward with the case. Tell me, are you a United States citizen? What happens if you go to jail, man?
Well, I don't want to go to jail.
I know.
Just say.
That's not my question. What happens if you go to jail? I want you to think and I want you to realize the consequence of behavior. So tell me, what happens if you go to jail?
No, pues. Missy has apoyo.
But my daughters would be without support, my family.
You're not in this country with permission. So if you go to jail and immigration finds you, there will put a detainer on you. And you're going to be in there for about 6 to 9 months. That's what you have waiting for you if you go to jail. Anything more than 4 hours, immigration sweeps it on a daily basis. I'm going to put conditions on you now. If you violate these conditions, I'll put you in jail. You will not get any more PR bonds. Do you understand?
Yes.
The relationship is the co-defendant to this person. Do you know?
Case Carpetta, congratulations, 18 months. Thank you, thank you.
I'm ordering you not to have any contact with this person. I'm also ordering you not to go back to JCPenney. If you violate these conditions, likewise, you know what's going to happen. You will not get any more warnings from us.
So no contact with the co-defendant?
Yeah.
Or the store?
Or going to the JCPenney.
Any other JCPenney?
Yeah, any JCPenney. Tell me, ma'am, what do you do for a living?
Trabajo en remodelación.
I work in remodeling.
Do you have a steady income?
¿Tiene ingresos estables?
No.
No.
Apply for an appointed lawyer.
¿Quiere aplicar por un abogado de oficio?
Sí.
Yes.
Okay, we'll give you an application. I need you to fill it out. I need to know everything about you. Do not just leave everything blank. I will send it right back to you. I need to know numbers. I need to know how much money you have coming in a month. I need to know how much money you spend. We'll have you take a seat in the jury box while you do that. Do not leave until you sign our bond conditions. Otherwise, I'll issue one for your arrest as well. And then we'll take a look at the application here shortly. Please, yeah. Anytime someone's not monitored, yeah, please.
All right, Judge, next is page 15. Montanez.
Been sent some spicy court documents to review. I'm going to watch Judge Fleischer for a minute while I get those prepped for you. But we might have some spicy court coming up.
Basilio Montanez, you are charged with failure to stop and give information, which is leaving the scene of an accident without exchanging information. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
On November 3rd of 2024, officers were dispatched in reference to a subject who struck the complainant's vehicle and failed to stop and give information. The complainant followed the defendant to the area of Green Meadow and Alice Road, where they waited for officers to arrive. Upon contact with the defendant advised officer that he struck a vehicle and said he did not stop. Officer observed fresh damage to the left front bumper of defendant's motor vehicle and to the left side of the complainant's vehicle. The complainant was positively ID'd the defendant and advised officer that as they were stationary at a red light, the defendant turned right and struck him. The amount in damages to complainant's vehicle was in excess of $200.
Okay. Mr. Montanez, I'm going to find that there's probable cause to go forward with the case. Do you have a Texas driver license, sir?
Yes.
Do you have liability insurance in your name?
Es la troca del patrón. It was my boss's truck.
No. I'm asking you if you have liability insurance in your name.
Estoy en la aseguranza del patrón también. I am under the insurance of my
I want to
boss's.
know for sure before you leave here, before we allow you to drive. Unless I see your name on a policy, I'm going to order you not to drive as a condition of your bond. I want to make sure that everyone in Harris County is protected in the event that you get into an accident. That requires you to have, anytime you're driving, you must have a Texas driver license and liability insurance. Do you understand? What do you do for a living, sir?
Trabajo de landscaping
Landscaping.
Stain, seal. I work in landscaping and
Sheetrock?
stain, seal, and many
seal.
things.
How much money do you make a month?
¿Cuánto dinero gana al mes? Al mes. Gano como unos de 900,000 por semana. It's like 900 to 1,000 a week.
Over 4,000 a month.
Como $4,000. Sí. Yes.
Okay. You will need to hire your own lawyer, sir.
I don't have a lot.
We're going to reset your case to give you time to hire a lawyer. So I will first have you go to Victoria, sign a reset, and then we will have you take a seat, okay? When you come back, please have a lawyer, sir. We will have you sign bond conditions that you're not allowed to drive without liability insurance. If you do, I'm going to put you in jail. You will not get more PR bonds. Do you understand? Okay, please. Can you file that no driving without a Texas driver license and liability insurance, please?
Okay, I'm reviewing this. We're about ready to read some documents.
Come on up. Where's Leila?
Okay. Well, while they do that, we're going to jump here. We are jumping to a new filing out of the Commonwealth of Massachusetts. I want to say Chootsits because they have T's in there. Ivan says, it's confusing to me that a person can admit to a judge they aren't a citizen and the judge has the ability to let them walk free after committing a crime. I don't understand. Probably because that judge is not the judge that would handle immigration issues. He does not have jurisdiction over that. That's most likely why. All right, we're going to jump. Ready? Here we go. We're jumping to right here. Yes.
Sexual.
Nope. This one here. Oh, I'm glad we jumped. Whew, that was a bad one. Commonwealth of Massachusetts. Yes, you're seeing Reed there in the corner. That is Karen Reed. There. Whoa. Why is that making noise?
Are we going to address subject matter jurisdiction?
That was terribly loud. Hit the wrong button on the wrong mouse. All right, here we go. New filings, brand new filings in Norfolk. Defendant Karen Reed's motion for relief from April 14th, 2024, order to impound sidebar conferences. The sidebar conferences, all the discussions that the lawyers had with the judge during the trial were recorded by the court recorder. And they were impounded, meaning they would not be released. Now comes defendant Karen Reed and respectfully moves this honorable court to release the transcripts of sidebar conferences that occurred prior to and during the trial in this matter from the court's April 14th order of impoundment. As grounds for this motion, Ms. Reed states that evidentiary issues that arose during the first trial will be subject to forthcoming motions in limine that will be filed prior to the commencement of the second trial, which is currently scheduled to begin on January 27th. Sidebar. Yes, you're right, sidebar. Without the ability to review the transcripts of those sidebar conferences and the rationale for the court's rulings, Ms. Reed will be unable to properly prepare for the trial. Ms. Reed further states that good cause no longer exists for impoundment of the sidebar conferences that occurred during the first trial. Under the Rule 7B, Massachusetts Uniform Rules of Impoundment Procedure. Ms. Reed further relies on the attached affidavit of counsel, which is incorporated herein by reference. As background, on April 10th, 2024, the Commonwealth filed its motion in limine for appointment of court stenographer, ongoing order to impound all sidebar conferences, and impoundment of juror names during trial. Attached hereto as Exhibit 1, the Commonwealth sought impoundment of the names of all jurors, all sidebar discussions, including sidebar, they want the names of the jurors, including sidebar discussions during pretrial proceedings, and that sidebar discussions and juror names will be unavailable until a verdict is returned. The Commonwealth's rationale was that the publication of matters discussed at sidebar, including juror names, information, and potentially sensitive responses to inquiry, while trial is ongoing, could prejudice the parties and expose jurors to extraneous matters. In its motion, the Commonwealth noted that after a verdict is returned, the potential prejudice to the parties will be greatly lessened, and that all parts of the record, except any that the court specifically finds subject to further impoundment for good cause, would then be made available to the public. The legal standard is under Rule 7. It provides that a judge evaluating a motion to impound documents may enter an order of impoundment only if good cause to withhold documents from the public is shown. To determine whether good cause is shown, a judge must balance the rights of the parties based on the particular facts of each case. There's some case law. Nixon v. Warner. Decision to grant access to court documents is best left to the sound discretion of the trial court, to be exercised in light of the relevant facts and circumstances of the particular case. Lots more case law. If there is good cause to impound documents, a judge is required to tailor the scope of the impoundment order so it does not exceed the need for impoundment. Basically, you can only lock up, as far as access from the public, the parts that you need to, and for as long as you need to. Once entered, an impoundment order remains an interlocutory order, subject to the continued existence of good cause. So you can only do it for as long as you are allowed, or as long as the need exists. If the need goes away, then you have to release it. Rule 8 of the Uniform Rules of Impoundment Procedure, requiring orders of impoundment to be time limited. And then we've got another case law indicating that impoundment cannot exceed narrowest requirements justified by good cause. Unlike other orders and judgments, an impoundment order carries no continuing presumption of validity to sustain it against a proper challenge subsequently brought. Previous orders are like, they're a standing order. I made the order, it stands for all time until I decide to change it. They're saying impoundment orders, where the court can lock up and restrict access to this information, does not carry that. That it doesn't just have the presumption of it's valid, it's still valid now. A party seeking the release of impoundment court records does not bear the burden of demonstrating either there has been a material change in circumstances or whatever good cause may once have justified their impoundment no longer exists. The burden of demonstrating the existence of good cause always remains with the party urging their continued impoundment, which means if Karen Reed's side says, we want the sidebars, give us the sidebars, they don't have to prove to the court why they should get them. And they don't have the burden to show that there's good cause or not good cause. It's all in the state. They have to reprove with this motion that these sidebars should be maintained in under impoundment. A proper challenge to the continued validity of an impoundment order is raised whenever the party seeking to modify the order comes forward with a non-frivolous reason to do so. They've come forward, said, we need this for the defense of our client. She cannot present her defense without so. This is non-frivolous. It might be a bit of a stretch, but it's non-frivolous. Once such a reason is before the court, the obligation of the motion judge is to apply the same balancing test used in determining whether to grant the impoundment order in the first instance. Now, the one part I've seen that stood out to me just a little bit is this. The original order said until a verdict is reached. We think we should keep these until a verdict is reached. And guess what? We haven't reached a verdict in this case. unless the Supreme Court, we listened to this hearing earlier this week, unless the Supreme Court comes down and says, yes, that counts as a verdict, we have not reached a verdict. So we'll see. I think the Commonwealth is still going to fight this. Because good cause no longer exists for the order of impoundment to be continued with respect to the sidebar conferences, and because access to those materials required for trial preparation is required, the impoundment materials should be released at a minimum to the parties. Okay, so they're saying even if you don't make them public, we get them. We get them. The order of impoundment related to the sidebar conferences was entered by the agreement on April 14th. The court issued a separate order of impoundment of the juror list on July 8th and extended that order in response to emergency motion by one of the deliberating jurors on July 18th. Let's see. That was findings and order on Juror Doe's emergency motion to extend on July 8th. Yes, so they kept the identities secret and still have. The identities of the deliberating jurors in this first trial in this matter remain impounded. That aspect, i.e. the identities of the jurors of the Commonwealth April 10th motion, remains unchallenged here, as the issue of juror identities was subsequently addressed by the court. Ms. Reed instead seeks only to release of the sidebar discussions that took place during the trial. So we're not saying we don't want the juror names. That we don't need that. Because it's gone to the Supreme Court, they're going to decide that, and they might kick it back and say, yes, you need to call the jurors in and panel, and ask them if they actually did reach a verdict. That might happen. Supreme Court might rule that in Massachusetts, but the defense doesn't need those names. Ms. Reed only instead seeks the release of sidebar discussions that took place during trial and those addressed evidentiary rulings prior to trial. Evidentiary issues raised during the first trial in this matter were discussed at sidebar. To the extent that the Commonwealth was concerned that the release of sidebar conference transcripts during the pendency of the first trial could expose jurors to extraneous matters, they were worried the jurors would hear about it. Since the trial is concluded, that issue is now moot. As the Commonwealth noted in its motion, after a verdict is returned, the potential prejudice to the parties will be greatly lessened, and that all parties of record, except any that the court specifically finds subject to further impoundment for good cause, would then be available to the public. But there's no verdict. That's the problem. A mistrial is when they fail to reach a verdict. Am I missing something here? The court has found that the identities of the jurors should remain impounded until and otherwise ordered by the court. With regard to the discussions of evidentiary issues at sidebar, however, good cause no longer exists for impoundment. Good cause instead now exists for the release of those sidebar conferences, insofar as Ms. Reed's right to a fair trial is implicated in her ability to draft and litigate, through motions in limine, evidentiary issues that arose prior to and during the course of the first trial. There's some case law that supports this argument that the sidebar conferences, meaning that this request is non-frivolous, which meets the standard, and it constitutes a proper challenge. So case law is on the defense side, at least in their request. In balancing the public's right to inspect documents against the defendant's rights guaranteed by the Sixth Amendment to a fair trial, a court may consider a variety of factors. These may include whether the information has already been disclosed, the name or the nature of the documents under impoundment, or whether there are alternatives to withholding public access, such as change of venue. There are, at this juncture, few aspects in this case that have not been explored in depth publicly. In fact, in its determination to continue the order of impoundment regarding juror identities, the court noted that this case has garnered significant and divisive attention in Massachusetts and across the nation. In other words, virtually every issue in the case, especially following a completed trial, has already been disclosed. Commonwealth versus Cruz. This factor weighs in favor of ending the previous order of impoundment. More case law. Another factor, the nature of the documents under impoundment, also weighs in favor of their disclosure. As noted, Ms. Reed herein seeks only the release of sidebar conferences, not the identities of the jurors subject to previous orders. To the extent deliberating jurors could have been exposed to the extraneous information the Commonwealth referenced in its April 10th motion, that concern ended with the jurors' service. Additionally, there are few, if any, privacy interests implicated by evidentiary discussions at sidebar. Rule 7b and case law says the extent of the community interest also weighs in favor of the release of the sidebar conferences from order of impoundment, while even acknowledging the court's duty to minimize the effects of prejudicial pretrial publicity. Now, they are going to have that. Okay, the judge, even though we've already been through it once, we have to protect the next jury from prejudicial pretrial publicity. I think that's going to be the state's strongest argument against this right now. Let me pin this so you guys know what we're doing. This is the Karen Reed document, latest and greatest. Thank you, Amber, for finding these for us. Though Ms. Reed does not bear the burden of establishing that good cause no longer exists for the order of impoundment to remain in effect and need not establish a material change in circumstances, she would be remiss not to mention that any good cause that did exist during the trial for this order of impoundment no longer does. The factors the court must consider in determining whether to continue its previous order of impoundment all instead suggest that reference sidebar conferences should be released at a minimum to the parties currently preparing for a second trial. For these reasons, Ms. Reed respectfully requests that this honorable court releases any sidebar conferences that occurred during trial and any pretrial sidebar conferences dealing with evidentiary issues from its prior order of impoundment. Ms. Reed further requests that this honorable court rule on this motion administratively without the need of a hearing. Boom, do it now. Do it now. And then we have exhibits. Lots of exhibits. Do I need to read the exhibits, Amber? Is there spice here? Waiting for Amber's response. It seems just sort of factual. Amber. Exhibits, yes or no? We pause now. Well, Amber, I guess she has work today. Like she has to do things, real things. I'll text her. Some you can skip these. The others are great. Okay, there we go. So now we go to, this is 408. Now we're going to go to, I believe 410. Yeah, 410. There we go. Send that to us. Close this one down. Get the new one. Okay, next document. Make sure you guys can see it, and you can. Next document is also the same case. Defendant Karen Reed's motion for discovery of communications in the possession of custody and control of the Commonwealth. This one gets good. Now comes the defendant, Karen Reed, and respectfully moves this honorable court pursuant to Mass R Criminal P14A2 to the order of the Commonwealth, to order the Commonwealth to produce all communications made by District Attorney Michael W. Morrissey, D.A. Morrissey, from his personal email address and or cell phone that constitute material and relevant evidence in this matter, including but not limited to any communications with witnesses, i.e. statements of witnesses, and any and all ex parte communications with the court and or other judicial staff concerning this matter. Whoa. We want his personal email and cell phone info. As grounds for this motion, this is a big ask. So these grounds better be solid. As grounds for this motion, recent reporting, corroborated by documentary evidence, demonstrates that D.A. Morrissey used his personal email address to communicate ex parte with Stoughton District Court personnel and judges. No, you didn't. But yes, he did. In the publicly available email sent by D.A. Morrissey to Justice Stacey Fortes, copying Massachusetts Trial Court Administrator Thomas Ambrosino, Justice Daniel O'Malley presided over Mr. Reed's case while it was pending. Be sure to read the footnotes, okay? while it was pending in the district court, Philip McHugh, deputy court administrator, and first assistant district attorney Lynn Belland. Let's see. Turtle Boy's defense claims DA lied about the evidence, improperly used personal email, available at NBC Boston. So this looks like one that non-traditional media dredged up. DA Morrissey attached what appears to be a text message or iMessage sent to a member of the prosecution by a witness in this matter that constitutes a discoverable statement pursuant to Massachusetts law. Oh my goodness. He used his private email. This email, and presumably a number of other communications that are material and relevant to Miss Reed's case or constitute statements of a witness, are in the possession, custody, and control of the Commonwealth, insofar as D.A. Morrissey is the District Attorney of Norfolk County. Miss Belland is his first assistant, and both are members of the Commonwealth for the purposes of Rule 14. Accordingly, Miss Reed respectively moves this Honorable Court to order the Commonwealth to produce any and all communications by D.A. Morrissey that are discoverable under Rule 14, as well as any and all ex parte communications with the court and or judicial staff regarding this case. An affidavit of counsel is attached hereto, as incorporated herein by reference. Factual background. On October 17th, Attorney Mark A. Attorney Bederow, filed a letter with this court directed to Norfolk County Special Assistant District Attorney and former Judge Robert Cosgrove. In his, subsection C says copy of the letter is attached. Oh, good, we get to read that. In his letter, Mr. Bederow detailed communications between Miss Jennifer McCabe, Miss McCabe, and yet unknown member of law enforcement, revealing that D.A. Morrissey had communicated on an ex parte basis with members of the Massachusetts Trial Court and Stoughton District Court, including the Honorable Judge O'Malley J. presiding. Let's see. Prior to indictment, Miss Reed's case was pending in Stoughton District Court with the Honorable Judge presiding. Okay, so he communicated ex parte there. What was number 3? Robert Cosgrove. Attorney Bedrow's letter is attached here to his exhibit. Oh, we've got exhibits. We have exhibits. In this email, which Mr. Morrissey sent from his personal email address while copying First Assistant Belland's official Massachusetts government email address, D.A. Morrissey detailed the fact that Mr. Chris Albert, another witness in the matter, had sought an ex parte harassment prevention order against Mr. Ayden Kearney, Mr. Kearney, Turtle Boy, which was denied by Justice O'Malley. Despite the fact that these hearings are public, D.A. Morrissey accused a member of the Stoughton District Court staff of leaking information about the harassment prevention order proceedings to Mr. Kearney. D.A. Morrissey alleged that Mr. Albert's affidavit in support of his harassment prevention order was improperly disseminated to a third party, i.e. the defendant of the harassment prevention order. D.A. Morrissey appended a text message or iMessage to his email from Miss McCabe, which reads, "I know it's late, but I'm horrified that Chris Albert didn't get it. And I'm even more disgusted for the second time someone from court leaked it right away to Mr. Kearney." D.A. Morrissey directly referenced this matter, which he referenced as the Commonwealth v. Reed murder case, in his email. He further notes in his email that the Commonwealth was informed by Mr. Albert and others that Mr. Kearney had been provided with harassment prevention order affidavit filed by Mr. Albert, indicating that a number of witnesses in this matter had contradicted either the Norfolk County District Attorney's Office, the Massachusetts State Police, or another police department involved in this case. Regardless, the Commonwealth has, vis-a-vis, D.A. Morrissey acknowledged that D.A. Morrissey acknowledged that it is in receipt of the statements from a number of witnesses in this matter, which were apparently withheld from the defense. Is it a discovery violation? You can have discovery even after a verdict's come in, right? Without citing any specific statute, rule, or regulation, D.A. Morrissey opined that the receipt of an affidavit in support of harassment prevention order by a defendant in that very harassment prevention order proceeding was completely unacceptable and must be resolved immediately, noting that the improperly disseminated court material being sent unsolicited to a third party, which is continuing to cause harm and damage to a witness in an ongoing homicide prosecution, must be a violation of court policies or a potential violation of law. D.A. Morrissey concluded in his email stating, "I understand that you have to do an investigation and that may take time, but you also have to provide us with some evidence and assurance that you have taken action so we can safely continue the use of the clerk's office in the Stoughton District Court." Legal standard. I need some water. You guys all watch me pour that down my shirt. There we go. The due process clauses of the federal Constitution and the Massachusetts Declaration of Rights require that the Commonwealth disclose to a defendant material exculpatory evidence in its possession or control. Okay, this is a discovery violation is what they're getting to. At this time, it is not known with certainty whom the recipient of this message was. The defense would note that this text message was not included in the previously produced text messages between Ms. McCabe and Trooper Michael Proctor, deposited with the Norfolk Superior Court Clerk's Office by attorney Kevin Reddington on February 15, 2024. Massachusetts law, a Declaration of Rights guarantees every criminal defendant shall have the right to produce all proofs that may be favorable to him, to be considered exculpatory and therefore subject to automatic disclosure. Evidence need only tend to diminish a defendant's culpability. A prosecutor's duty to disclose extends to all facts within the possession, custody, or control of a member of the prosecution team. We saw this in Alec Baldwin's case. The prosecution team generally is understood to include prosecutors and relevant law enforcement personnel. Put differently, a prosecutor's obligations extend to information in possession of a person who has participated in the investigation or evaluation of the case and has reported to the prosecutor's office concerning the case, including state police crime laboratory chemists within prosecution team, including victim and witness advocates within the prosecution team, and excluding complaints and independent witnesses unaffiliated with investigation from the prosecution team. So it includes medical examiner. So yes, medical examiner. Yes, lab chemists. Yes, investigators, law enforcement. Yes, victim and witness advocates, but not independent witnesses unaffiliated with investigation. All those people, if you are on the yes category and you have some information that could be considered exculpatory, it has to be turned over to the defense. On request, prosecutors also must disclose material and relevant statements of persons within their possession or of persons within their possession, custody, or control. A statement is defined as a writing made by a person having a percipient knowledge of relevant facts and which contains such facts signed or otherwise adopted or approved by such person, or a stenographic, mechanical, electrical, or other recording or transaction thereof, which is substantially verbatim recital of an oral declaration, and which is recorded contemporaneously with the making of the oral declaration. Any victim or witness statements in the possession, custody, or control of an advocate are subject to a discovery order. The prosecutor must determine whether the advocate's notes contain such statements. Prosecutorial misconduct that is egregious, oh my goodness, they're going here, deliberate or intentional, or that results in a violation of constitutional rights may give rise to a presumptive prejudice, and the drastic remedy of dismissal of charges may become an appropriate remedy. After double jeopardy has taken effect, is applied, dismissal, it would be dismissal with prejudice. D.A. Morrissey's communications are within the possession, custody, and control of the Commonwealth, and constitute material and relevant evidence or statements of witnesses pursuant to the provisions of Massachusetts law. It is axiomatic that the district attorney himself is a member of the Commonwealth or the prosecution for the purpose of Rule 14. Noting the prosecution team generally is understood to include prosecutors and relevant law enforcement personnel. The use of a personal cell phone or email does not shield otherwise discoverable information from production. And case law supports that. Text messages sent or received by state employees on personal cell phones that pertain to official business are public records. Massachusetts law provides that the defendant may move, and following its filing of the Certificate of Compliance, the Commonwealth may move, for discovery of other material and relevant evidence not required by Subdivision A1 within the time allowed by Rule 13D1. More law. The law requires as mandatory discovery that the Commonwealth disclose material and relevant police reports, photographs, tangible objects, all intended exhibits, reports, and physical examinations of any person or of scientific tests or experiments and statements of persons the party intends to call as witness. The work product rule exempts from discovery those portions of records, reports, correspondence, memoranda, or internal documents which are only the legal research. opinions, theories, or conclusions of the adverse party or his attorney and legal staff. Rule 14 preserves the core of the work product doctrine by sheltering the mental processes of the attorney. The doctrine encompasses prosecutors' notes made in preparation for trial, including notes from the interviews with witnesses. Proper preparation of the case demands that prosecutors assemble information, sift what they consider to be relevant from the irrelevant facts, prepare their legal theories, and plan their strategy without undue and needless interference. This work is reflected in interviews, statements, memoranda, correspondence, briefs, mental impressions, and personal beliefs. Affirming judge's denial, more case law, the case law affirms judge's denial of discovery request for notes of prosecutor and his investigators relating to conversations with witnesses after prosecutor represented to the judge that notes constituted work product. So work product is exempt, but this doesn't sound like work product. Deanne says, slow down. This is spicy. This is Karen Reed and her team asking for DA Morrissey's private email and cell phone text messages and saying, we have case law on our side. He sent a message, a private message on his private account that does not shield it from discovery. It's treated exactly the same as if he sent it from his work email. There is no indication that anything in the publicly available email sent by DA Morrissey from his personal email address could reasonably be construed as constituting work product. On the other hand, DA Morrissey's email includes a message from Ms. McCabe that would constitute a statement under Massachusetts law and which should be disclosed to the defense. As noted in the reporter notes for the rule, prior informal statements not intended for court are not only often admissible at trial, but often more probative than formal signed statements in anticipation of litigation. On this view, if the police have taken a statement of a witness who will testify, it should be discoverable to the defense. As noted above, DA Morrissey appended to his email a message sent by Jennifer McCabe to a yet unknown member of the prosecution team that reads, I know it's late, but I'm horrified that Chris didn't get it. I'm even more disgusted that for the second time, someone from the court leaked it right away to Mr. Kinney. Since this message was not included in the communications received by the defense in response to a Rule 17 motion directed to communications between Ms. McCabe and Trooper Michael Proctor, it was presumably received by another member of the prosecution team. Given the tone and informal nature of the message, apparently sent late in the evening, it seems unlikely that this was the first occasion on which Ms. McCabe contacted this person. The communication further suggests that some level of coordination between Mr. Albert, Ms. McCabe, and members of the Commonwealth in their decisions to seek harassment prevention orders against Mr. Kearney. As also noted in this email, DA Morrissey told the recipients that the Commonwealth was informed by Mr. Albert and others that Mr. Kearney had been provided with the harassment prevention order affidavit filed by Mr. Albert, indicating that a number of witnesses in this matter had contacted members of the prosecution team. Oh my goodness. I need to read horrified. Setting aside whether these communications constitute statements under Massachusetts law, subject to ministerial discovery, on request, prosecutors also must disclose material and relevant statements of persons within their possession, custody, or control. Ms. Reed had herein requests that any communications constituting statements of persons the Commonwealth intends to call as a witness at the second trial in this matter be produced. I see a loophole here. If they decide not to call Jen McCabe, they can get out of sending this, possibly. A prosecutor is expected to actively seek out any exculpatory evidence held by the Commonwealth or other member of the prosecution team. A prosecutor's obligation to disclose exculpatory material is just that, an obligation, not a decision. Case law reiterates the prosecutor must disclose exculpatory information. As noted above, informal statements not intended for court are not only often admissible at trial, but often more probative than formal signed statements in anticipation of litigation. It's these little statements outside of court that aren't supposed to be here. Amber forwarded these to Rob at Law and Lumber and Ian and a couple others. So they've got them. It's these little statements they make before they get in court that are often very insightful. Furthermore, though a defendant need not make such a request to mandate disclosure, Ms. Reed requests that any material exculpatory evidence contained in D.A. Morrissey's private communications concerning her case, which is a matter of public interest, be disclosed. To be considered exculpatory and therefore subject to automatic disclosure, evidence need only tend to diminish a defendant's culpability. Part 2. D.A. Morrissey's ex parte statements regarding this case are improper, not protected by any privilege, and should be produced to the defense such that it may determine if extraneous influence was asserted over members of the trial court or any other party related to this case. Ex parte communication with a trial judge is contrary to the basic values of fairness governing litigation under our adversary system. You have case law for that. D.A. Morrissey's ex parte communication with trial court justices, including the very judge who presided over Miss Reed's case while it was pending in the district court, and his demand for evidence and assurances that action had been taken by the Stoughton District Court, is extremely concerning and raises concerns about the integrity of this prosecution. The judiciary's independence from the other branches of government and from outside influences and extraneous concerns has been one of the cornerstones of our constitutional democracy, intended to ensure that judges will be free to decide cases on the law and the facts as their best judgment dictates, without fear or favor. The writings of John Adams, as our founding fathers said, preceding the drafting of the adoption of the Massachusetts Constitution, developed and articulated the essential linkage between judicial independence and impartial decision-making. He said, "Judges' minds should not be distracted with jarring interests. They should not be dependent upon any man or body of men. To these ends, they should hold estates for life in their offices, or in other words, their commissions should be during good behavior, and their salaries ascertained and established by law." They shouldn't have to, petition for their own position. Nobody should have power over the judge to make them decide something in a certain different way. Those are thoughts on government in 4 works of John Adams. In regards to enft of subpoena, I don't know what that meant. Since D.A. Morrissey cannot in good faith assert any work product privilege or other privilege with respect to his ex parte communications about this matter, Ms. Reed respectfully requests that this honorable court order production of all such communications, noting that case law says judicial deliberative privilege by definition does not apply to ex parte communications during deliberative process. Any documents provided to the judge by the probation officers would also be available contemporaneously to the defendant, and any ex parte communication on substantive matters is strictly prohibited. In the event of ex parte communications on purely procedural matters, notice must be provided to the applicant promptly following such communication. We've seen this before. If you're going to do ex parte, where do we see this? We saw this in Young Thug. If you're going to do an ex parte meeting, the other side has to be either aware it's going to happen or right after it happens, be given the information that's pertinent to them to say, hey, we just met ex parte, this is what happened, and this is the part I can tell you. Including the substance of the matters discussed, and the applicant must be given an opportunity to provide his or her input on the matter before any decision is made. It says, in formal litigation, ex parte communication intending that the judge rely on the information relayed is unacceptable. It is contrary to the basic rules of fairness governing litigation under our adversary system and is not to be countenanced regardless of any rule of court on the subject. Wow, they've got case law. Conclusion, for the above reasons, Ms. Reed respectively requests that this honorable court orders the Commonwealth to produce any and all communications by D.A. Morrissey that are discoverable under Rule 14, as well as any and all ex parte communications about or concerning this case. I don't know if they have met the standard for, what do they say, anything that slightly lessens culpability, right? Let's see what it says. I think it was up here. I'm not sure. There it is. Here it is. Evidence only need to tend to diminish the defendant's culpability. They'll have to. I think they have to meet that for this to be, for that threshold to be met. And I don't know if they'll get the wide open door of give us everything once we meet this threshold that they're asking for. But we have one more document in this series. 412. Where's my mouse? What? My screen's moved on me, so I have to go to the right to get to the screen on the left. That's no good. Last document on this Karen Reed update today. Defendant's response to Commonwealth's notice of scheduling reassembly and testing defendant's Lexus telematics system. Ooh. Do I see a new phone in DA's future? Or the old one getting thrown away on an Air Force base? Now comes the defendant, Karen Reed, and respectfully files defendant's response to Commonwealth's notice of scheduling reassembly and testing of defendant's Lexus telematics system. As set forth herein, the Commonwealth's new digital forensic expert, Shannon R. Burgess, has opined that there were deficiencies in the chip-off procedure conducted by defense expert Maggie Gaffney on the defendant's Lexus infotainment and telematics system as a result of what he claims may have been programmer's error. As set forth herein, Ms. Reed objects to the Commonwealth's position with regard to the new testing protocol as follows. 1. Defendant vehemently disputes Ms. Burgess's characterization of the chip-off procedure conducted by Ms. Gaffney, which is based on Ms. Burgess's fundamental misunderstanding of the difference between a megabit and a megabyte. They're different. And it has to do with size. They're substantially different. Ms. Reed respectfully requests that the court adopt the protocol proposed by defense expert Matthew Segura for any future testing of the infotainment and telematics system, which properly accounts for Ms. Burgess's misunderstanding relating to the storage size of the chips in question, and seeks to prevent further mistakes by Mr. Burgess, which could result in the unnecessary destruction of evidence. Let's see, on October 11th, the Commonwealth filed the Commonwealth's notice of scheduling, reassembly, and testing of defendant's Lexus infotainment systems, requesting that its new digital forensics expert, Shannon Burgess, be permitted to engage in further potentially destructive testing of Ms. Reed's infotainment and telematics system by conducting the chip-on procedure. The Commonwealth's request is premised on two opinions offered by Mr. Burgess regarding the analysis of the telematics and infotainment system associated with Ms. Reed's vehicle. They want to retest the car. Okay, this is the GPS. This is the system that tracks when it was in park, when the brakes were pressed, how far the gas was pressed, the speed of the vehicle, the locate. It's got all sorts of stuff in this. It's not really focus on the infotainment. Other than the infotainment, the screen is also able to show radio stations and Sirius radio and maybe even DVDs. I don't know, but they want the data about where the car was. So they want to redo this. The first time they got faulty data with the chip off. Now they want to reassemble it, sort of like put the pieces back together and then test it again. Let's see. They say that the evidence acquired in the December 2003 chip-off was incomplete, and there is more data that was not acquired that exists on the chips, and that new hardware and software updates have been developed since the chip-off was conducted in December 23, which may assist in interpreting the data. Highly qualified defense expert Matthew Segura, a licensed professional engineer and certified IPC specialist with Delta V Forensic Engineering, Inc., has reviewed the chip-off work conducted by Ms. Gaffney, and opines that Mr. Burgess misunderstands certain basic digital forensics concepts, including, inter alia, the conversion of megabytes to megabits, negating certain of his opinions and necessitating that certain extra protocols be put into place to prevent programmer error by Mr. Burgess. They're saying that once again, the Commonwealth has faulty Faulty people, experts on their side. Don't break it further, Mr. Burgess. As set forth below, Mr. Burgess's incorrect belief that the initial chip-off procedure failed to retrieve all the data because of programmer error stems from his misunderstanding regarding the storage size of the chips in question. Notwithstanding that fact, Ms. Reed consents to a chip-on procedure for the sole purpose of determining whether any of the updated software or hardware may assist in interpreting the data contained on the components in question. Mr. Burgess fundamentally misunderstands the difference between a megabit and a megabyte. That's in bold. Oh my goodness. In his declaration, Mr. Burgess incorrectly concludes that the defendant's digital forensics expert, Maggie Gaffney, failed to extract all the data from the two modules in the vehicle when she conducted the initial chip-off procedures in December 2023. Mr. Burgess' opinions and conclusions are based on his incorrect belief that the prior chip-off procedure conducted by Ms. Gaffney resulted in 3 files totaling only 8 megabytes in size, when they should have been closer to 64 megabytes in size on the total flash memory component of the chips in question. As explained in the attached declarations of defense expert Matthew Segura, Mr. Burgess misunderstands the difference between megabytes and megabits. In point of fact, manufacturing specifications establish that the total flash memory component of the chips in question is equal to 64 megabits, not megabytes. Significantly, 64 megabits is equal to 8 megabytes. Thus, Ms. Gaffney successfully acquired 8 megabytes of data from the chips during December 2003 chip-off, which constitutes the total flash memory component of the chips in question. Converting megabytes to megabits is a basic digital forensics concept, which is critical to the successful data acquisition and analysis. Mr. Burgess's failure to properly record the total memory capacity of the components at issue could cause the Commonwealth to seek and perform unnecessary destructive testing, which could, in turn, result in the unnecessary destruction of evidence. So a megapint is similar. Yes, Stacy. If a megabyte's you, you've been a megabit. You've been megabit. As explained in the attached declarations, let's see, we got that one. 64 megabits is equal to 8 megabytes, so it was right. Accordingly, as set forth below, the defense respectfully requests the defense expert be permitted to be present during any future testing conducted by the Commonwealth, and that the defense expert be permitted to halt any testing and seek court intervention if Mr. Burgess makes any future mistakes which risk comprising the data at issue. They're literally saying, your smart people are going to break it because they're not smart. Let our people be there to just make sure you don't destroy everything. The defendant's proposed amendments to the Commonwealth's proposed protocol regarding the examination of the infotainment and telematics system. New and updated Burla software, which did not exist prior to, or at the time Ms. Gaffney conducted the initial chip-off procedure in December 2023, could potentially assist in decoding additional information from the Lexus infotainment and telematics system at issue. As a result, Mr. Reed requests that the Commonwealth be permitted to conduct further testing with oversight by a defense expert. The first step of any acquisition protocol is to properly record, inter alia, the memory storage capacity of the components the expert intends to test. The Commonwealth's expert failed to do that here. As explained in the affidavit of defense computer expert Matthew Sagra, I'm not sure, we're going to call you Matthew because I can't get your name right, which is filed herein through Mr. Burgess's infotainment data acquisitions protocol. Mr. Burgess incorrectly reports the total memory storage of the components at issue. Ms. Reed respectfully requests that Mr. Burgess's proposed infotainment data acquisition protocol be updated as follows to prevent any programmer error during future testing. Oh my goodness. It's operator error, not programmer error. They're saying the Spanison is a 64 megabit flash memory component, not a 64 megabyte flash memory component, as Mr. Burgess incorrectly states. Notably, 64 megabits are equal to 8 megabytes, which suggests that all available data was successfully retrieved during the first acquisition. This is right. If you can hold 10 things in your hands, and you took everything that if somebody took everything that was in your hands and counted them, and they had 10 things, putting those things back in your hands and recounting them will not make 11 things. The 11 does not fit. 10 is all you can hold. They already got everything they could from this chip. The Micron JWB57 is 4 gigabits flash memory component, not a gigabyte flash memory component, as Mr. Burgess incorrectly states. Notably, 4 gigabits is equal to 500 megabytes, which is half of a gigabyte, almost. 512 would be half, which suggests that all available data was successfully retrieved during the first acquisition. The Micron chip is a 2 gigabit flash memory component, not a 2 gigabyte flash memory component, as Mr. Burgess incorrectly states. Notably, 2 gigabits is equal to 250 megabytes, which suggests that all available data was successfully retrieved during the first acquisition. Additionally, Mr. Burgess proposes that he perform additional chip-off acquisition attempts to ensure complete data capture. This step is unnecessary because all available data was successfully retrieved during the first acquisition. In other words, the file size of the acquisition already matches the expected memory storage capacity of the components. They were full. The chips were full. They took all the data off. They got everything the chips could hold as a result. And he says, we're going to go back and retest them. They're not going to get any more. However, as explained by Mr. Disagra, I think, Matthew, sorry. Mr. Burgess should conduct an acquisition to ensure that the contents of the memory chips have not been altered by confirming the checksum of the chips in advance of any further testing. An alternative proposed protocol for examination of the infotainment and telematics system, which was prepared by defense expert Matthew Disagra, a licensed professional engineer and certified IPC specialist, is filed herein. As set forth in the protocol proposed by Mr. Disagra, the defense respectfully requests that defense expert Matthew Disagra be permitted to be present during any future testing conducted by the Commonwealth and be permitted to temporarily halt any testing if Mr. Burgess attempts to engage in any testing, which risks unnecessarily compromising the data at issue, such that the defense may seek court intervention. This is hilarious. It is not uncommon for a defense to say, we'd like our expert to watch the process or be involved, at least as an observer in the process. But for them to say, look, we are so worried that the state's expert is going to break everything because he doesn't even understand the basics of what he is doing, that we'd like him to have to follow our procedures, which have some checks and balances and some verification involved in it, and use the correct data. And we not only that, we want our guy to be there when he does it and have the right to say, stop, step back, don't touch anything. I'm going to talk to the judge because you're screwing it up again. Oh, my goodness. They did not incorrectly remove it the first time, Wu-Tang Flare. No, they got it correctly, but the expert thinks they did it incorrectly. But the chip size shows they got everything they possibly could. In conclusion, for the foregoing reasons, the counsel respectfully requests this court adopt the proposed protocol prepared by defense expert Matthew Disagra, which is outlined in the affidavit of defense computer forensics expert Matthew Disagra and is filed herein. And herein he has his exhibit of this is how we say you should do it. I have a Bachelor of Science from UNC. Little shout out to UNC there. And a Master of Science, also Mechanical Engineering from UNC. He's got certifications. Boom, he's good there, looking good. Employment preference or employment experience. He's done forensic stuff. Hey, he worked with General Dynamics. I worked for them a long time ago. I was GDIT, not GD Cameron Detection Systems. They're GDCDS. I was GDIT. Let's see, continuing education. These are all the YouTube videos he's watched. I'm just kidding. These are classes. He's been published extensively. He's done presentations. He's a member of professional organizations, including the Society of Automotive Engineers, professional accident reconstruction specialists. So he's legit. He could be certified as an expert. I think they're going to get it. What does this motion do to Bev? Who does it go to? Does it go to Bev? Yes, this would go to Bev, Judge Beverly Canoni, and she's going to decide. The law is really in favor of defense in almost every aspect, except for the part where it talks about a verdict. This impoundment of data from the sidebars, that was intended to exist until a verdict had been reached in the trial. We have not reached a verdict according to the state, the Commonwealth. I think that's going to be an issue that they fight. And they say, no, we still have to keep this separate because there still is potential for a jury to hear this information if it gets leaked publicly. And we don't need them to hear this extraneous information that carries on to the sidebar. So that's going to be a tough point for them. I think they will win, though, the argument for discovery, because they do have a copy of a transaction, an email or a text message that they should have received in discovery and didn't. And so I think that opens the door to sort of pry a little bit. I don't know if they'll find anything else, but they might win that one. What in the world? My husband's a land surveyor, just found a burned body tied to a porch. Melissa, I'm assuming he has already called 911. And maybe a lawyer. I'm just kidding. I think he's probably good. His work can vouch for him. That is crazy, Melissa. What state is that in? Police are there now. Can you give us the state that it's happening? You don't have to give us specifics if you don't want to, but Tennessee. Is he like, okay, the tied to the porch? That worries me. Are we really going to make Recovery Addict talk this long without hearing one of our off-topic stories? This is crazy. It's disturbing. Obviously, it's going to be investigated. Typically, when a body is found either bound, if it's tied, or with external injuries not accounted for immediately in the presence of the body, it becomes a homicide investigation. I have a picture. It's terrible. I can imagine. Yeah, your hubby if this goes to court, he might find himself on the witness list. For sure. Yeah, don't share the picture. We don't want to see that. No, don't want the picture. That picture probably would end up in court, or a version of it. This is for Halloween. That would be the best thing, but I doubt it was. That's crazy. We can always hope it's a very realistic Halloween prop. But the police would be able to determine that pretty quickly. You thought it was at first? Any idea age-wise? Are we talking adult? Man. Let me see if I can find if there's anything publicly going on about this. I searched social media for this, and unfortunately, there's like 70 different cases that have similar fact patterns going back a couple months. Oh my goodness. I'm muddling up my Google searches. It's okay. I'm logged in as you, Ivan. I should be good. Wow. So I'll pack up and go to Tennessee and solve this. That's bizarre. Surveyors, I imagine surveyors are often called out to when there's a change of hands in property, or there's either they're trying to subdivide a property or sell it or something like that. A surveyor is brought out for that purpose. So it makes you think a little bit. You know, what was going on with the property? Why now? Was it tied to a porch? Next topic. I'm curious, but I don't want to know. You know, I don't want too much. I don't want to know too much. It's good to have a friend in the surveyor biz. Man, that is wild. If you can, keep us in the loop a little bit. I'm sure this will probably make the news. This is a bizarre situation. It was a bridge inspector who found Gannon. You're right, Genjo. Wow. On that topic, are we ready for a little bit of lunch? I mean, that is wild. No, Sistisha. No, not ready for lunch. It's lunchtime, and I'm hungry. I think Mrs. R.A. has been shopping as well. Fingers crossed. It's our shopping day. You want that call?
Call from
Ivan.
Ivan,
do I want this call, though? How are you doing, man?
Oh, yeah. Changing the topic back to the documents. I'm getting back to being on task and on topic here. I got a quick question about what we just read here.
Yeah.
So, what is preventing what is preventing him from just scrubbing all of the emails and texts? Now that this is a formal request and it's out there that they're seeking this. To me, it just sort of is giving like a heads up if he would want to, get rid of anything that he might not want discovered. I mean, what's stopping him from doing that?
Well, if he does get rid of it, and they search other ways, like other people who are involved in the text message chain, and say, we have a received message from you on this end, but no sent on your side. That would
but would it automatically give them, like, if they get permission to go into his, that doesn't necessarily give them permission to go into everybody else's who he sent things to. Like, that would seem to me that would be a different warrant, a different chain of custody to me.
Right.
No.
There's at some point you have to say, look, you're a professional, you know the law. You can't be deleting stuff.
So we're just Scouts honor. That's what we're going. I hope for, because I mean there is no. I mean, he has no order to not delete them. They're not part of evidence as it stands. And now that he knows that there is a desire to have them, it wouldn't technically be illegal for him to scrub them.
It would be unethical.
Oh, wow. Okay.
Some people can lose their jobs over ethics violations. So I think I don't know. I don't think he would delete it. He's high enough up that it would basically end his career. I think if he did.
You think it would be that serious?
Yeah.
Oh.
Of course, if he just was already planning on replacing his phone, and he just happened to take it to an Air Force base and throw it away in 3 different garbage cans after snapping the SIM card. Then, of course, there's no fault there.
Touche. All right. Well, just a question I had. That side of my brain, while it's been in the back burner for many years now, that part of my brain always fires off, some impulses when I hear things like, well, we just have to hope he doesn't, or we just have to take his good word, or, to me that doesn't seem like it's always enough. But
there may be other ways they can get this, especially if they've got a judge's official communication. Some of the emails went through publicly disclosable routes. So FOIA requests might be able to turn these up without a court order through other ways. So, yeah. How's Bitcoin doing today?
Bitcoin is sitting around 76,000. Hit another all-time. We're in price discovery mode, which for people who don't know what price discovery means, anytime a stock or any kind of commodity in and of itself hits a new all-time high, it's what you call price discovery. And that means it is testing its new boundaries, so to speak.
It's unshackled, and anything could happen.
Yeah,
it could say,
correct.
100,000 is our next limit.
Right. Well, that's just it. And so, price discovery is where you want to be. It's always exciting when a commodity hits an all-time high, because at that point, it literally means everybody who is holding that commodity is in the green. Everybody, whether you're up 10 cents or 10 million. When you're in price discovery mode, everybody's in the money. And
I'm closer to the 10 cent side on that. Just for for full disclosure, I own closer to 10 cents than 10 million.
Well, wherever we're at, hey, my business mentor, he says you can be a bear or you can be a bull, but just don't be a pig. Never be ashamed of taking a profit, no matter the size.
All right.
So,
well, I've got to get into my wallet, so you'll need to help me figure out how to do that. But
without getting too nerdy here, for people I take it you don't have any idea where your passphrase is?
Oh, I have a Bitcoin address with a whole bunch of letters, hexadecimal. I've got the secret.
Right.
I've got the share. I've never made an account. This was gifted to me, and I never moved it. It's been sitting in the account where it was gifted to me since the 11th of January, 2014.
Oh, excellent. Do you know what's the name of the wallet? Do you know? What?
It says bitaddress.org, but it tells me to go to blockchain.info or mountgox.com and sweep them, is what they say.
Awesome. Well, if you shoot me a text of the random letters and codes, and I can look up the wallet's value for you on the blockchain and to show you what you're dealing with.
It's not much. I think we're under $1,000.
Well,
I can tell you it is. I think it's like 0.00566893 Bitcoins.
Well, as it stands right now, it's at 76,000 right now, and so you said it's 0.05?
0.005. It's tiny.
0.005.
It's
0.005 would be about $450.
There we go. It's enough money for a new grill.
Yeah.
A cheap new grill, which would bring about a recession, as we've talked about before. But
10-4. All right. Well, I'll give you.
It was $5 in 2014. I know that it was $5 worth of Bitcoin.
Right. Well, yeah, that's about right. That would be about right. Like I said, when I first got in, it was right around 600 and something. So, but yeah, so that would be in the same era.
Yeah.
So, but all right, man.
Awesome.
I'll give you a buzz tomorrow about it.
Sounds good. Have a good one. See you, Evan.
All right.
Bye.
Yep. Bye.
All right. Sorry, the Bitcoin talk was to get us off the burn talk. which would now enable us to transition from this to lunch smoothly. Got to take taxes out of that. Oh, taxes, taxes are for my accountant to figure out. I found one who does it very cheaply and does a good job. And she might charge me more after this year's escapades into cryptocurrency. Not that I made any money. I mean, I guess I made a few dollars, but not enough to seriously affect the grocery shopping we do for a single week. Okay, and unfortunately, though, I still have to report everything a billion times over. And I bought and sold the tiniest portions of coins ever, like literally under $1 sometimes, purchases and sales. And I guess I have to report everything. My accountant is going to hate me for it. I need her to fix it so the IRS doesn't come after me. They already have me on the blacklist. All right, you guys, tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better. And please stay safe till we go live again. And after lunch, I'm going to run to the post office. Apparently I have a package. Kiki D, thank you very much. Possibly two, Debbie, maybe. We'll see if it arrives. But guys, have some lunch. Have a good time. We'll be back this afternoon. A little more court hopping. Hopefully have a new trial next week. Fingers crossed on that one. Like watching real live trials with you. But we'll be back shortly. Maybe we'll go back to Judge Fleischer. He seems to still be doing stuff. So we might come back to him after we go back. You guys have a good lunch. We'll see you.
Because he's the guy.